We're able to hear you. Are you able to say something so we can make sure we can hear you? Well, I don't think this is going to work with him.
I could call him, Judge. If you just give me a second. He probably needs to try to reconnect and connect again. Because it kind of sounds like he can't hear you. Or
Text him.
yeah, I did. Quick call.
We'll come on Instagram.
No, I have his phone number. We're texting right now. Everybody's here, Judge.
All right. Is Cindy in the back? All right, thank you. Yes. And were you all able to Zoom that document to me?
No, not yet. I'm not too sure what's going on, but maybe you're connected to me. She's still not here, Judge, but she's okay. Okay, just try to play around with it and see if you can connect. You rest. Okay. Good morning.
Good morning.
Judge, I need to reference an exhibit that's already been entered with this witness as well. I don't know if the court reporter's here already.
You can go in the back to see if she's here.
Okay, I'll go take a look.
You have the microphone?
She's coming.
Oh.
Morning. All right, can you unmute?
No, no.
All right. Just remain there. Okay, where did the defense counsel go?
Shoot to the back.
Okay,
Good morning, Judge.
good morning. All right, so what we'll do is we're going to see if she wants this witness first or this witness first. Okay. All right, thank you. Counsel, your
Yes.
witness is on and they're able to hear us.
Okay, great.
And we have audio. Did you want to call them first?
Yeah, sure, I would.
Right.
Who's going first?
It is going to be the person by Zoom. So if anyone can get that exhibit, and if y'all will just scan it to me, and then I can do the screen share so that he can see it. Hello, Jenny. So we're gonna start with this trial. They have two witnesses. My understanding, they're short witnesses. So probably if everyone is back here by 10:30, we'll be ready to proceed. All right, thank you. We're waiting for Cindy to set up. So does anybody want to go through the box to see the exhibit number? What's the okay, yeah. I think this is. I think that's an exhibit. No, it's this one. There's that.
And you just want it scanned, Judge?
Yes.
Yes.
Okay, Judge, it should, should be on its way to you.
All right, thank you. Mr. Rodriguez, are you able to see State's Exhibit number 19 on your screen?
Yes.
All right, thank you.
Thank you.
Ready for the jurors, Judge?
Just one moment. All right. Court is calling 2025 CR 0000700, 2025 CR 0000701, State versus Felipe Reyes. Can I have parties announced? State,
Andrew Harris, Edelman, and Megan Galloway, State.
defense,
This is Pauline Portillo for Mr. Felipe Reyes.
and you're Mr. Reyes.
Yes, ma'am.
Are both parties ready to proceed?
Fence is ready.
Yes, ma'am.
All right, let's bring the jurors in. And we're on the record. Defense, it's the court's understanding that with regards to State's Exhibit number 19, you want the witness that's by Zoom to see the video, to see that exhibit? Is that
Yes,
correct?
yes, Your Honor.
Do you have any objections to the court using the share screen so that the witness can see State's Exhibit number 19?
I have no objections.
All right, thank you. And, if you have somebody print it out, for me, Georgia.
I just need a USB.
We'll mix it.
Ready, Judge?
Yes, we're ready.
All right, for the jury.
Okay. All right, thank you. All right. Everyone, please be seated. All right, the state had rested its case and defense. Call your first witness.
Defense calls Joshua Luis Rodriguez.
All right, ladies and gentlemen, this witness is by Zoom. Any objection to the witness appearing by Zoom? State,
No, Judge.
defense.
None, Your Honor.
Mr. Reyes, do you have any objection to this witness appearing by Zoom?
No, ma'am.
All right, Mr. Rodriguez, if you can raise your right hand for me, please. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Make sure you keep your voice up so that the members of the jury can hear and the court reporter can hear. If you'll state your name for the record.
Joshua Lewis Rodriguez.
All right, defense, you may proceed.
Good morning, Mr. Rodriguez.
Good morning.
Go ahead and spell your complete name too, just for the court reporter. Just make sure. she has-
Joshua Joshua Lewis Lewis Rodriguez Rodriguez.
And so you're not testifying in person today. You reside in Houston.
Correct.
And do you know Felipe Reyes?
I've known him for a couple of years. Yes,
How do you know him?
he's a business partner of mine. We're in the music industry together.
Okay, what does he do specifically in that industry?
He's a videographer.
What does that involve?
Music video shoots, mostly.
How long has Felipe been doing that for, if you know?
He's been doing it for a couple years, but prior to the day I met him in 2023.
And through the course of his business, who does Felipe mainly work with?
He works with a lot of artists in the city, in the surrounding cities in Texas.
Are you familiar with his Instagram page?
Yes,
Judge, I'd like to publish or tender State's Exhibit 19 to the witness, please. All right, Mr. Rodriguez, this exhibit's already been entered. This is the Instagram page for Trap Visions Studio. Do you recognize it?
yes.
Okay, and is that the business name for Felipe's videography business?
Visions Film, correct.
Okay, and so the abbreviations in his biography, are you familiar with those as well?
Yes.
What can you walk us through what they stand for?
I'm gonna start from the top. As far as the Houston videographer, DME means direct message. The credits 1501 and TSF are rap groups in Houston, including SUC, abbreviation for Scoot Up Click. One of the founder groups here in Houston. Swisher Blast also as well. And Dope House is short for Dope House Records. And the SPM and Juan Gotti are in that group.
So do those abbreviations have anything to do with narcotics?
No, ma'am. Those are rap groups here in Houston that are the leading founders of the city. They're showing everyone how to get involved with the music industry.
And is it your understanding that he was coming to San Antonio the weekend of October 27th, 2024?
He was going to San Antonio for a videography video shoot.
Stop speaking. When there's objection that is made, you need to stop speaking.
I
Do
didn't
you
know.
understand?
And Mr. Rodriguez,
And what is your objection?
Relevant, it's lack of going on with your saying.
With regard to hearsay, that objection will be sustained. You can ask your next question.
So the weekend of October 27th, 2024, was Felipe in Houston?
Yes,
Okay. Did he stay in Houston that weekend or did he go somewhere else? If you know.
I believe he was leaving the city.
Okay, and at the time he left, did you see him take any of his videographer or photography equipment with him?
Yes,
Okay. What did he take with him?
mainly everything except for his computer.
Okay, what's everything? Sir, what do you mean by everything? What exactly?
He took a camera, lights, I believe different fixtures for the lights, stands, tripods, I believe.
Pass the witness.
All right. State.
Mr. Rodriguez, so it's your testimony that you've known the defendant since 2023, is that correct?
Mr. Rodriguez, it's your testimony that you have known the defendant since 2023. Is that correct?
That's correct.
And you stated that he's your business partner. Is that correct?
Yes, ma'am.
Okay, and if we look at the state's exhibit number 19, can you see that on your screen?
Yes, I zoomed in. I could see it.
Okay, and so where it says booking hit up at Romy Rome H Tex, that's your personal Instagram, isn't that correct?
The name changed to promo instead of HTX at the end, but correct. That was the name at the time.
Okay. And as far as him being your business partner, can you explain the financial relationship that you had with him?
Yes, so we agreed to work together. I would help get bookings for him, but mostly his bookings were consistent with my showcases. I do my own artist showcases in Houston, so he'd help me with the videography, and we'd help each other get exposure.
Okay, and were you guys sharing financial proceeds with each other from those bookings?
Sometimes I would pay him, correct?
Okay. Now you previously testified that, well, I guess when we're talking about screwed up click, what does
Right.
screwed mean?
It, you're asking me what does it
Let's
mean?
stop. There's been an objection. What is
Okay.
your objection?
Objection to relevance.
She opened the door. He's previously testified that it's not associated with the narcotics industry when it is.
All right, that objection will be overruled.
What does screwed up mean?
Screwed up in the terms that their founder was DJ Screw, and he slowed down a lot of music. So when screwed up click is abbreviated is for the slowed down music part.
Okay, and DJ Screw is a famous rapper from Houston, isn't that correct?
I believe so.
Okay, and the reason that he would chop and screw music and slow it down is because he was high on promethazine, isn't that correct?
Just 1 second. Your objection?
Relevance.
All right, what's the objection?
That
I mean,
he's
sorry, what's the
testifying,
response?
he's testifying that it's not associated with narcotics industry when it is, and the jury needs to know the true meaning of these terms.
All right, that objection will be overruled.
And isn't it true that DJ Screw would slow down music because he was high on promethazine cough syrup known as lean?
Objection to speculation.
All right, if you have personal knowledge, you can answer the question.
I don't believe so. I believe because the music was slowed down, everyone wasn't used to that type of music. So I believe that's the reason why they used screwed up click as a abbreviation for their group.
Okay, but my question was, did DJ Screw ingest promethazine cough syrup?
Objection to asked and answered. The witness already said he doesn't believe so.
That's not.
All
what
right,
I'm
the
saying.
objection to asked and answered will be overruled. Any other objections?
No objections.
All right, you may re-ask your question, please.
Isn't it true that DJ Screw was famous for ingesting promethazine, also known as lean in the rap industry?
I believe so.
Okay, now moving on. Swisha Blast. Isn't Swisha associated with Swisha Sweets?
I don't believe so. I believe the name entirely was for a DJ, Michael 5000 watts, who'd also do the same thing, slow down music as well.
Okay, so what is the significance of Swisha?
I'm not sure their intent to use that name. I think it's a very popular name here in Houston.
Okay, and it's associated with Swisha Sweets, which are cigarillos used to smoke marijuana. Isn't that
Counsel
correct?
Testifying objection to speculation, objection to relevance.
All right, with regards to speculation, that'll be overruled. With regards to testifying, that objection will be sustained.
Swisha Sweets is associated with cigarillos. Isn't that correct?
I believe so.
Okay, and cigarillos are used to smoke marijuana. Isn't that correct?
Correct.
Okay, moving on. Dope House. You said that SPM is a member of that rap group,
Yes,
and does
along with
that sound
others.
okay? Does SPM stand for South Park Mexican?
Correct.
Okay, and the group is called Dope House, correct?
Dope House Records.
And it's your testimony that that has nothing to do with narcotics use or distribution?
I believe Felipe used those abbreviations to show the status of videography and the people he works with.
Well, what does dope mean? Dope is associated with illegal narcotics, isn't that correct?
Dope can be used in a lot of ways.
And one way is the use of illegal illicit narcotics, isn't that correct?
I believe so.
Okay. And you're familiar with the defendant, is that correct?
Yes,
Okay, and so you've seen him in person before?
correct.
Okay, and isn't it true that he has a tattoo on his right arm that says
Objection,
Trap.
Your Honor, relevance. An
visions?
objection to evidence not, to information not in evidence at this point.
All right, that objection to relevance and the other objection will be overruled.
Isn't it true that the defendant has a tattoo on his right arm that says Trap Vision?
Trap visions, yes.
We pass the witness, Your Honor.
All right, defense.
Mr. Rodriguez, those substances that the prosecutor just referenced, do you know Felipe to use any of those?
Objection relevant.
That'll be overruled.
Overruled, I'm sorry.
Yes,
It was
you can
overruled?
answer the question.
No, ma'am. He's never been under the influence.
Have you ever observed him to use any of those?
No, ma'am.
And dope, what other meanings could that word have?
Like cool, or in the sense that, oh, that was a dope video shoot. You know, it's kind of the slang they use here in Houston.
And do you know Felipe to associate with any of those record labels?
Yes, I've actually worked around him, working with some of those groups.
Sorry, outside of for his work purposes?
Can you repeat the question?
Yes, do you know Felipe to associate with any of those organizations outside of his videographer and photography business?
No, ma'am.
Pass the witness.
No further questions.
All right, is this witness excused or subject for recall?
He is by the defense, Your Honor.
Excused, Your Honor.
All right, thank you.
Thank you.
All right, defense, call your next witness.
Defense calls Detective Robles. I need to go. You write down, please write down.
All right, you're still under oath. If you'll restate your name for the record, please.
Yes, my name is Detective Matt Davis with
All right, make sure you keep your voice up so that members of the jury can hear. Defense, you may proceed.
Thank you, Your Honor. Okay, good morning, Detective Robles. So I wanted to ask you, through the course of your investigation as a narcotics covert detective, what is your goal when you have a case with multiple individuals in a possession case like this?
with multiple individuals.
Yes.
Probably to determine possession, who fits the criteria for possession, depending on the direction of the case and what we're trying to accomplish.
So are you trying to look for one person specifically to determine possession?
No, the evidence.
Okay, what type of evidence are you looking for?
So possession would be not necessarily ownership, but in possession of it, control, physical control of it, having it on your person or within your proximity. Things of that nature.
And what about, in addition to possession, what else are you looking for? What are the other elements of possession?
The other elements you're asking specifically, what are the elements of possession?
Yes.
But like I said, so not necessarily ownership, possession would be like you're in control of it. Somebody tells you to hold it, or you have it stored in a pocket or in a backpack or in your vehicle, that you're able to, you're reaching a lunging area, your gravel area where you're able to obtain it when you need.
And aside from ownership, what else is important to find out?
I'm not sure where.
So when you arrest somebody for possession, right, you have to have probable cause that they possessed a controlled substance, right? And mere ownership is not enough.
Correct.
And so what else do you need?
For field tested to build that probable cause. Marijuana being a little different, where if we see marijuana based on our training and experience, I could essentially determine that this is marijuana compared to other substances, which would need a presumptive test before we could consider it being probable.
Do you know if a field test was done in this case?
I'm aware that it was done. I don't believe that it was done on scene.
So it was done after Felipe was already taken into custody.
I wasn't the case agent for that, so I don't know when the determination or what time he was considered arrested at that time.
What about the required mental state?
The required mental state?
Yes.
Could elaborate on that, if you should.
So somebody can own something.
Potentially knowing.
Somebody can own something without, or possess, right? Have it in their care, custody, and control without knowing that they have it. Would you agree with me?
I'm gonna object as to it's calling for a legal conclusion and invading in the province of the jury.
That objection is sustained.
So somebody that you arrest for possession, right?
Yes, ma'am.
Do they have to know that they possessed?
Well, typically I ask that question after they were read their Miranda warning. You want me to go into in this particular case? No?
So that's important.
Yes, ma'am.
Okay.
A couple of minutes.
Here you're trying to get somebody to acknowledge possession. Is that correct?
I wouldn't say I'm trying to get him to acknowledge anything. I'm trying to figure out what the circumstances are for his possession, or why he's in possession of it, or what led us to this place that we're here talking to each other.
And in doing that, do you talk to the multiple individuals that are involved with the incident?
Those that come in, that I come in contact with, I try to get a whole picture of it.
So you spoke to the multiple individuals that were involved in this case?
I spoke to two, maybe three different individuals.
Besides my client?
That would be two others probably.
Two others, okay. Do you remember talking to the female in this case?
I do not remember.
And we have your body worn camera. You do mute multiple times, is that correct?
Yes.
And what does your policy say about when muting is allowed?
So our policy, given my position within the department, I'm a covert detective. So I wear plain clothes and I essentially operate in a covert capacity. So our policy states that anytime I come in contact with a source or a potential source, potential confidential informant, I'm allowed to mute my body camera for the protection of that source. And also for tactics to discuss tactics with our fellow detectives, our fellow officers, so that we don't give out kind of the way we operate and the things that we do.
Would you agree that there are some points of your body worn camera that are muted where you're not talking about confidential informant?
There would be for case tactics.
So every other time you muted, your testimony is that it was for case tactics.
Yes.
Even if you were talking to other individuals at the time that you muted your body worn camera?
Other officers, other detectives, or
The suspects.
anytime I was going to talk to a suspect, if I needed it, it was maybe trying to ascertain if they were interested in becoming a source or an informant.
Can you say definitively if that was the case each time you muted when you talked to those suspects?
As far as my recollection, that's what it would be.
Do you recall after you found the backpack approaching one of the individuals, not my client, but another one of the males?
Yes.
And you approached him and told him, guess what I found in the backpack? Do you remember that?
Yes.
And so initially you approached him as a suspect for the backpack contraband.
Again, I'm trying to take a whole picture to see if, and as a matter of fact, when it comes to interviewing somebody like that or debriefing somebody, it's not in my best interest to show my cards, but in this situation, giving them that opportunity, I wanted them to have a full picture of context of what we were looking at, and that's why I told them that.
And did you get an answer you wanted?
No,
And then you told him, remember that when you're doing time. Do you remember that?
yes,
Okay. And you told him you had already talked to his
Okay.
homeboy.
I'm gonna object as to hearsay and relevance as to his
Sustained.
So the next person you go to talk to is my client, correct?
Yeah.
And do you recall telling one of the officers that you were going to go tell him you found his backpack?
I'm gonna object as to hearsay.
That'll be overruled.
so
Do you recall telling one of the other officers you were going to go tell Felipe that you found his backpack?
I don't recall my exact words.
Okay, would it help refresh your memory if you were able to review your body worn camera?
Yes.
Did it help refresh your memory?
Is that where you want me to stop?
Well, did it help refresh your memory?
Yes.
Okay. So now, do you recall telling the other officer you were gonna go tell Felipe that you had found his backpack?
Yes.
At this point, you don't know if he's spoken to any of the other detectives, do you?
I don't believe at the time I knew whether he had spoken to anybody.
So is it possible that he did speak to other detectives?
It could be.
Is it possible that any of the other detectives already told him what they had found in the bag?
Objection, speculation.
Sustained.
Do you know if any of the other officers had spoken to him and told him what was in that bag
In that moment, or as I know today,
in that moment?
in that moment, no, I don't know.
So Felipe tells you that he understands he doesn't have to talk to you, but then he starts to tell you something else. Do you remember that?
Don't remember the specific words, but I do remember him wanting to talk to me.
Do you remember cutting him off?
Excuse me?
Do you remember cutting him off at times when he's giving you a statement?
I don't, I mean, maybe, I think it's possible.
He told you he didn't know any of the individuals that he was with. Is that right?
I don't remember specifically. I think I'd have to refer back to my video.
Right again.
Your color, this-
Mhm. Doesn't go bad with your suit though.
Oh, thank you.
The help refresh your memory?
I don't, it didn't specify whether he stated he talked
Right.
about the other,
Uh,
I'm sorry, I can't.
Yeah, if you'll take off the headphones now. Defense, you can ask your question.
Did he indicate to you that he knew the individuals personally?
No, he had stated that he knew of them, not personally.
Okay. Do you remember him telling you that it was the female who told him he had to throw the bag?
Objection, hearsay.
Sustained.
So Felipe, when you're talking about what you had found in the bag, right? There's multiple times when he's telling you none of that stuff has anything to do with me. Do you remember that?
Again, I'd have to refer to the,
So there's a point of about 3 minutes when you mute your body worn camera. Do you recall that?
I do recall muting I don't know exactly when I did.
Why did you do that?
Again, so he was being very forthcoming with what had happened. And so I took his cooperation as maybe an opportunity to see if he would consider being a source.
Did he?
Yeah, he was, he had told me that he was interested in that. And for me personally, as a detective, I don't work with anybody who's not going to be upfront and honest with me. He was being honest, so I felt that there was an opportunity there. So we had talked about that, and that's why I needed my body.
So it's your testimony that he told you he was interested in working with you. So what information did you all talk about at that point?
We talked about the specifics of that night and why he was in possession of the backpack and why he threw it. And that he was doing it for the money. And he was helping somebody out that he wouldn't be paid until he got to Austin.
What did you talk about during the muted part of the conversation?
That's for his safety, it's something that I'm not necessarily comfortable talking in person about or in public about. He was basically providing other information on other narcotics issues or situations that he knew of.
Okay, so you mute for about 3 to 4 minutes. And then right before you mute, do you remember him saying he doesn't want to be on paperwork?
Yes, and what that means is.
And be careful because you don't know exactly what he meant by that, right?
But we talked
So
about it.
after he got out of the car, what's the next thing he's doing?
When he got out of the car.
Yeah, what's the next thing you have him do?
We talked about paperwork situation.
What's the next thing you have him do once he gets out of the car?
He volunteers to sign an acknowledgement of contraband.
And that acknowledgement of contraband lists out certain items, correct? And the first item that's listed on there is not written by him. And there's also no reference to other particles that were found in the bag. Is that correct?
I would assume so. I'm not too sure it's specific. I was present when it was being signed, but I don't know verbatim what's on there. Do you have a copy?
Yes, I do. My question about the form, is there information, I'm sorry, is there particles that were found in the bag that were not included in this list of items?
Particles, what you mean by?
Items.
Oh, items, you said articles. I thought you said part, I'm sorry. Items, I would assume so. There's other things that are in the back that are not listed on.
So how important was that voluntary acknowledgement form to you all charging Felipe with what you charged him with in this case?
The importance, I couldn't tell you what the importance to the case agents. I can speak for me. The voluntary acknowledgement of contraband is just another layer of what I would call admission, essentially. He's admitting to the contraband. Is it necessary? No, it's not necessary to proceed with the probable cause or an arrest. It's just another way of him saying, hey, I'm acknowledging this is what I have and I want to cooperate. And so typically we'll pull this form out when we're looking at opening up that line for him to be a source of information.
Do you remember telling him what to put on the form?
Yeah, I told him, to put what you had.
Do you remember actually telling him which items to put on the form?
I don't remember exactly, again, I have to look at the video, but I do remember telling him, hey, this is on your own free will, I'm not forcing you to do any of this, this is up to you, if you want to do it, if you don't have to do it if you don't want to. And I asked him if he understood his rights, he did, I said, you know, you can stop talking to me at any time, and he elected to continue.
Pass the witness, Your Honor.
Any questions?
Briefly, Judge.
It's, oh, they're all right there.
Detective, I'm gonna publish State's Exhibit number 4, which has been entered into evidence.
You have the right to remain silent, anything you can't say and will be used against you before the law. You have the right to have to talk to a lawyer, and have the lawyer present while you're being questioned. If you cannot afford a lawyer, one will be appointed to represent you before question if you wish. You can decide at any time to exercise these rights and not answer any of these questions or make any statements. You understand that? Yes. You understand you don't talk to me, right? I understand that. Okay, so tell me what happened. Yes,
Okay, so on State's Exhibit number 4, who is the person in the purple that we see as arm right here?
That's Ravens fan, Detective Ramirez.
Okay, and we heard Detective Ramirez read the defendant his statutory warnings, also known as Miranda rights, correct? And the defendant acknowledged that he understood those rights, correct?
Yes.
And you further reiterated that the defendant did not have to speak with you, correct? And he stated that he understood that, correct?
Sure.
Okay.
So, took us, they asked me to drive a car, right? So just clean car. They said it was gonna be clean, we drove from Houston and we landed there. I took a nap right there. Whatever business they had going on, it was their business, you know what I'm saying? And then when we're about to leave, they gave me a bag. It was under my seat. And when you say that, sorry to cut you off, man. When you say they, who's they? What do they go by? What's the name? I don't know. I don't know. I just know one dude. That's it. His name's Nate. I just know Nate. Nate? I just know Nate, yeah. Which one?
So I'm gonna pause State's Exhibit number 4. How long have you been a narcotics detective?
Approximately about 5 years.
Okay, and so what is the significance of a clean car in the narcotics industry?
So typically, if you're gonna be transporting narcotics, a clean car would be a car that has insurance, a car that has, the registration is not expired, all the, technicalities like the lights, the rear registration light, the lights of your license plate, or you don't have a broken windshield or a crack on your windshield, something like that, that would not, have a police officer who's driving along the highway next to you, spot you and pull you over for something, insignificant or, something where you're not gonna draw attention to yourselves.
Okay.
With tattoo?
Yeah, with tattoos.
Okay.
Uh,
He's the one that has tattoos all over his
yeah,
face?
yeah, he was in the hey, just drive my car down. And I'm to San Antonio, and then you gonna stay over here, and then we're gonna go get some meat over there in Austin. When we have a clean slate, you know what I'm saying? And I'm like, okay.
Did you owe him some fatty or you owe him some money?
No, I needed some extra bread money, you know what
How
I'm
much
saying?
was he gonna kick you?
I don't know, and we were down to discuss it, we got to Austin, and we're good.
And we just heard the defendant state that he needed some extra bread. Is that also a term known in the streets as money?
Money.
Okay.
Like Austin, was supposed to be a clean car, you know, but, she brought it back, and we were supposed to go leave clean, you know?
Yeah.
Wasn't like nothing. And then, you know, like, he was like, well, you know, you guys lit up the lights, and I had to toss to the back, you know?
Yeah.
You know, we're all scared, you know, and she didn't see this curve. And
Okay, so I don't want those firefighters to get hurt. They have to pull that car out from under that hose. Is there any more dope inside that car?
there shouldn't be no more, it's just that bag.
Is there any guns or anything in there?
There's no guns, no.
Okay,
That I know, to be honest, I don't know.
I appreciate you being honest.
I'll be honest, if you guys, you know, I'm helping you out, we can tell you the truth. Just please just get my camera back, you know, I'm a videographer. I was just here just to film some content in Austin. And so I drove the clean car because and then I brought my equipment, you know. I was really supposed to just record some content, we're supposed to go out to eat, record some content, vlog, you know.
Are any of these guys rappers or something?
Nah, no,
Okay.
you know what I'm saying? I'm just trying to cover myself because but
So just so that we're on the same page, you were gonna come out here with them and they were gonna keep you some money, they were gonna pay you some money to drive.
yes, it's dirty, so yeah, that's the dirty shit. I had the clean car. Like the gray car was clean when I drove it down here, you know? You know, 'cause it was just going to the line.
Who's this girl that's with you?
I don't know her.
You don't know that
I
guy,
don't know the dude, he's the dude that doesn't have tattoos. I don't know him either.
but you know homeboy with
Yeah,
the tattoos.
I know him, you know.
Okay,
Um,
do you know how much you had in that bag?
I don't know, to be honest, sir, like I said, none of that stuff has nothing to do with me.
Well, it does.
Yeah, well, I just know it does because I threw it back.
Okay.
But
Did you know what the contents, what inside was? Did you know that it was
like, I just know there was stuff inside of it.
stuff, you mean like what?
Like, I don't know, like I said, I just know.
You're saying you're being honest, and be honest, what did you think was in it?
Probably pills, ice, you know what I'm saying, like,
So the ice from methamphetamine?
Yeah,
Meth?
sir.
Okay. What,
Okay, and so at this point, have you put any words in the defendant's mouth as to what was in the backpack?
not at all.
Okay, and so you do clarify, what does ICE mean in the narcotics trade?
Methamphetamine?
Okay, but that was out of the defendant's mouth, correct? That there was pills and ice in the backpack, correct?
I just said that by top of my head, that's about it, you know.
And so why did you throw the bag?
I'm scared, sir.
No, but why did you throw the bag? Did you see somebody behind you or what?
No, you guys lit up the car, you know.
The police cars?
The police cars,
They try to stop you?
They tried to run, you know.
Mhm.
And that's, you know, like I said, like, I just to throw
Were
the
you on the phone at the time that you were talking, that this was all going down?
No,
So who told you to throw the bag?
Huh?
Who told you to throw the
The
bag?
girl.
The girl told you to throw the bag?
Yes, sir.
Okay.
Okay, and so just regarding the phone, you asked the defendant if he was on the phone during the time of the offense, is that correct?
Yes, ma'am.
And he stated he was not?
Correct.
Okay, and in order to get search warrants for phones, you would need to have a nexus to the offense, correct?
Yes, ma'am.
And so that was not present here, correct? Okay.
Okay. You have any questions? Are you willing to sign a voluntary acknowledgement of contraband? Meaning that was in your possession and that you threw it?
Yes, sir.
You willing to sign that? Okay, we'll get that taken care of. Do you need it? I don't know if you need it, but if you want it, you can get it.
Like I said, I just want this I just don't want this to show up my paperwork, sir, you know what I'm saying?
Yeah, I got you.
I'm telling you the truth, you know what I'm saying? Like,
Well, what do you know that you can help us out with?
And so what is the significance of paperwork when working with confidential informants?
So any paperwork that's done when it comes to confidential informants is done in a very, a controlled environment. The paperwork that is signed is just acknowledging that he's not a police officer. That is my job to protect his identity. I'm somewhat responsible for the safety of the informant. And so it's just essentially paperwork laying out those responsibilities, and that he's not to portray himself as a law enforcement officer.
Okay, and so the reason that a person wouldn't want to show up in paperwork like that is because their life could be in danger, correct?
Correct.
All right.
You know what I'm saying? If we're gonna talk about that, I'm gonna turn my camera off and then we can talk offline, okay?
Okay, and so you mute your body worn camera at this point, correct?
Yes, ma'am.
And that's after telling the defendant that if you were going to speak about him providing any other additional information, that you were going to mute it, correct?
That's correct.
And it's your testimony that you're doing that for his safety, correct? All right.
And this is the address. How is up, right, let him. This is where we live. This is where he's a right, we're gonna pick him up. Down here. Right here, you know, was you're gonna write what you do, what's in that, right? I have the right to an sign, and I'm gonna say now, say that, and my trial. Anything that will use as evidence against me in court. I have a right to if I fire question, I will put more errors. I have the right to have more funds of fire and question. This one that the law fights. I see no issue, and maybe verify me that any secret proceedings I get fired, single can. Maybe this thing, no, I ain't talking to me, but I'm really breaking fire. Get to the set. That the person who was saying is you know that this is about everything. Everything informed of my constitutional rights. I was telling without any promise for cars and knowledge of all the items the country and found of the kind of stuff. I was the preceptors at San Antonio County and my care custody show. And that I alone am responsible for the longest that I have to consequence. So just look at, I don't threaten you or tell you you have to say this or that, right? Okay. And you're doing it the bottom, what does it say here? Where? We're doing the what, like right here? Yeah. I have. That's right. San Antonio, alright. Did you acknowledge that, because you're thinking throughout the back, right? You're acknowledging that the following items of contraband found over there on the premises of, the address, right? In the city of San Antonio, Bexar County, were in my care, custody, and control, which they were, right? And that I alone am responsible for the below listed items of contraband. So what it means is that you were in possession and control of that. You threw them out, you're claiming that this is what you had. Okay, that's what that means. So.
Okay, and so at this point, we see Detective Ramirez reading the defendant his statutory warnings for a second time. Is that correct?
Correct.
All right, and you made it clear to the defendant, you asked him if you were threatening him or telling him to sign that in any way, and he denied that, correct?
Correct.
All right, and then I'm gonna play the state's exhibit.
Yeah, I want you to write what you believe to be in the bag. You write what you think is in there and how much. I can't tell you the exact size. Okay, just write a description of what it was. With the color, what were they wrapped in? This, they take the armory, I see some bags, I think, the color of the pills were, I see some. How many pills do you think, like, just an estimated guess? You're talking about 3, if I'm being 50, 100? I'm being 100% honest, so like, I told you to be honest, I'm being honest, with you, I don't know what to talk about. So what else was there in the bag? So there's meth? You agree there was meth in there? Yeah. Okay. Do you agree there was pills in there? Was there any weed in there? Okay, marijuana, weed. Okay. What else is in there? What color was the bag? Put that on there. Blue and red bag? Yes, okay. What kind of bag was it?
And so at this point, you've asked the defendant, does he agree if there was methamphetamine in there? And he said, yes, correct?
That's correct.
Okay, and anything else that you mentioned, it was stuff that he had already told you, is that correct?
Yes.
Okay, and so we see the defendant writing this out in his handwriting, responding to what you're asking him, is that correct?
That's correct.
All right, and earlier, we did see you explain the form to him and what possession means under the law, correct?
Yes.
Okay, was it a satchel, was it a backpack, or was it a backpack? And what did you do with the used? Somewhere. What kind of vehicle was it? Sign right there.
Okay, do you know what the street value for methamphetamine is currently?
Objection to relevance.
It goes to
The
the,
relevance.
it goes to the intent to deliver and the defendant's motive for delivering the narcotic.
All right, overrule.
You can answer.
So generally, it's gonna go based on the region or the locality to determine the price because of its availability. But locally, here or Houston, you're looking at anywhere from $20 to $40 for a gram. 3.5 grams for an 8 ball. Anything over an 8 ball, in my experience, I would consider not personal use. Anything under than that, I would consider personal use.
Okay. And do you know what the street value for fentanyl is currently?
That fluctuates so much that I couldn't give you, again, and that's availability and region.
Okay. Now in your experience as a narcotics detective, what is the significance of the word trap and trap house in the industry of narcotic distribution?
Objection to relevance.
Relevancy.
Judge, the defendant's Instagram is Trap Visions, and so I think the jury needs to be aware of the meaning of that.
All right, that'll be overruled.
You can answer.
So a trap or a trap house is indicative of a house for storage. Typically, in my experience, people will rent out a place or sublease a place so that it removes their name from any type of documentation that identifies them as having a financial tie to the place. And typically it's stored there, sold there. You got a lot of traffic. And it's usually a rundown house is a trap house.
Okay. And in the narcotics industry, what is the significance of the word dope?
Dope is
Objection to relevance, Your Honor.
Relevancy.
Well, Judge, the prior witness testified that the word dope house on the defendant's Instagram wasn't associated with narcotics use. So
Overrule.
you can answer.
So dope is in a law enforcement perspective, it's narcotics, and it could be any marijuana, cocaine, methamphetamine, anything dealing with narcotics is dope.
Okay. And so earlier there was some mention that you told another officer that you were going to tell the defendant that you all found his backpack. And so why would you do that?
Just to check his brass, if he's being honest, or He can dispute that if it's not his bag. I wanted to see what his position was, what he was gonna say.
Okay, and did you earlier state that you want him to be able to make a decision based on all the facts that you were aware of on that?
Yeah, so typically, when I'm gonna work with somebody, as far as this first, I want them to make it, because it's a very sensitive situation, and I want the person to understand the whole context of it, and for him to make a decision whether he wants to talk to me or not. I know I'm an officer and he's on the other side, but, we're people, and, I want to make sure that he understands what he's doing, and so that was the reason for that.
Okay, we pass the witness, Your Honor.
All right, defense.
Yes, Your Honor. So Detective Robles, when you're reading the statement to Felipe, do you notice him looking around and not paying attention to the sheet that you have him filling out?
Are you talking the portion where we're on the hood of the vehicle?
Yes.
I mean, I'd be speculating.
No,
I'm not
it's
really
not.
paying attention to what he's looking at. I was trying to give him instructions.
How are you not paying attention to him if it's your goal to make sure that he understands what he's signing?
What I mean is, like, I'm not looking at where he's looking. I'm trying to explain the form to him.
And you explain the form as signing this form just means that you had the bag with you, correct?
I explained it to him. He's acknowledging that he was in possession, and I asked him to write what he was in possession of.
And do you recall him, in response to you telling him what to write, he's going along with it? Do you recall him saying, mm-hmm?
I don't recall.
Do you recall when you said weed and there was weed, he said, maybe, I don't know, let's put it in there.
He said, let's put it in there. I said, let's put it in there.
He said, I don't know, maybe let's put it in there after you told him weed.
I'm not, I don't recall the.
Okay. I'm gonna play State's Exhibit, whatever, 4,
Yes.
at 1:31:15.
Was there any weed in there? Marijuana, weed?
Does that refresh your memory?
Can you turn it up just a tad?
Sarah, what if I'm turning it
Well, if you give me the mouse, I can.
No.
Was there any weed in there? Marijuana, or what was his, I can't understand his response. You know what his response
Yes.
was? I don't.
Well, we'll let the jury hear it when they go back to review.
Okay.
So during these statements, has he received any medical attention after the crash?
I know there was an ambulance that was called out there. I don't think that he, I don't know if he was looked at before I attended to him or not. I'm not too sure.
That had been important to get him medical attention first before speaking to him?
Sure.
They keep stating to you that he was driving a clean car. Is that right?
He described a clean car from Houston.
Okay, and could it be possible that that meant that there were no intentions to possess any drugs or anything illegal?
Objection, speculation.
Sustained.
During that muted conversation, did you tell Felipe how much time he was facing?
No.
You didn't tell him that he would face up to 75 years for the contraband that was found?
Not that-
And you didn't tell him that he would be the one getting charged with all the contraband?
I might have said that. I'm not sure.
Did you indicate to him that you could help him if he cooperated?
Yes,
And you said you took that cooperation as an opportunity, correct?
correct.
Are you aware that only $20 was found on Felipe?
No.
So this much drugs, if you can't pin possession on somebody, what do you do?
We would place it in the property.
Do you charge somebody?
If you can't pin it on somebody, no, you wouldn't charge anybody. I don't.
So with this many, with this amount of drugs, it's possible that you didn't have to make an arrest that night.
It would be possible, yes.
Have you ever done that with that many drugs? Not made an arrest?
When somebody is going to cooperate, yes.
Have you ever not made an arrest in a case with this many drugs?
I'm gonna object as to relevance.
What's the relevancy?
It goes to the officer's investigation in this case and whether or not it was completely unbiased and impartial.
All right, that would be overruled. You can answer the question.
Repeat your question.
In a case with this amount of drugs, have you ever not made an arrest?
Yes.
Pass the witness.
No further questions, and he's excused by the state.
All right, thank you. You may step down, leave the microphone.
Yes, I know. Take it next time.
Any other witnesses?
Yes, Judge, may I approach briefly?
Yes. All right, everyone, just stand and thank you. Just stand and let me know that you are here when I call your name. Janesha Walker. Janesha DeJohnia Walker. Janet Silva is custody. Dinesha Walton, she was actually on Zoom. Constance Sinwell, custody. Cynthia Deanna. Maxwell McDarius. Maxwell Brian McDaniels. Kenneth Howie, custody. Ashley Jones.
She's in custody.
All right, thank you. They have her as listed as on bond. Deputy, can you make sure? Leroy Smith. Thank you. Terrence Scott,
He's here with me, Your Honor. We're conferring.
thank you. Lawrence Cloud, custody. Michael Arojo, thank you. Simon Garza. All right, thank you. Kimberly Essex, custody. Cortez Pope, that's reset for the 28th for competency evaluation update. Paul Marceau. Jerson Rios, custody. Adriana Ramos. Jose Martinez Cardenas, thank you. Roxanne Hayes. Fatima Malera Leonor, custody. Curtis Wilson, thank you. John Tharnert. John Arlen Tharnert. Roger Blanco, custody. Larietta Holmes, custody. Michael Medellin. Amari Greenwood, Kenneth Howie, custody. Malik Lampkin, custody. Claudel Carney, custody. Jorge Sandoval, Daryl Payne, George Hawkins, custody. Is there anyone whose name wasn't called or you came in late? Yes, what is your name?
Maxwell McDermott.
Maxwell Modernis. McDarris. All right, you need to be on this side on the second row. Yes. All right, second row. All right, to the attorneys here, what's going to end up happening, this may have been the state's last witness. If so, we're going to do closing arguments, then I'll take up the cases that are on the docket. All right, defense, are you proceeding with any more witnesses?
Yes, Your Honor.
All right, is that going to be your client?
Yes.
All right, then he can take the witness stand. Hi. Yes. Right. We can bring the jurors.
Let's do the rest.
Ah, okay.
Defendant's Exhibit 5, that
Oh, it is.
the video, Robles video.
Stapler remover.
Talking about, like, it was just a.
You said
I
defend,
stated I don't know what you're talking about, then I don't. If
Okay.
you want to refer to it by the officer, I can. do that.
Robles body worn.
It's in the computer.
it's you.
Yeah.
You said defendants exhibit 5, and this is state's exhibit 4.
I misspoke. It's Exhibit 4.
It's in the computer.
Okay, could I pull it up?
No problem. Oh, you can give it to them.
Start looking at that. And yes, thank you. And highlight those
All right,
portions.
so to the parties, with regards to the jury charge, the only thing that's going to be removed will be the fact that he testified. So I won't kill any more trees if you'll just notate the page number, but I'm going to have one that has the correct number of pages.
Thank you, Your Honor. And then this copy has the 38.23 instruction.
Yes.
Thank you.
All right, let's bring the jurors in if they're ready. Okay. And defense,
Yes.
your request is actually on page 9, so that'll be in there.
Okay,
And then the only thing is that page 9, of course, will become page 8,
okay.
but
thank
it's
you.
there.
Everybody's here now, Judge.
All right, we're ready.
All right, for the jury.
All right, everyone, please be seated. Defense, call your next witness.
Defense calls Felipe Reyes.
Would you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. Make sure you keep your voice up so that members of the jury are able to hear. All right, you may proceed, defense.
Okay. All right, Felipe. Where are you from?
I'm originally from Mexico, but I live in Houston, Texas.
And how old are you?
I just turned 29 on April 10th.
And during the October 2024, during that month, did you visit San Antonio?
During that weekend, yes.
Okay. Would you frequently take trips to San Antonio?
It'd be like a handful of times, you know, whenever I had to do a videography job out here. You don't have a rapper just rent out an Airbnb and, we come out here and record the music videos out here and, San Antonio's a very lively place, so of course, people wanna, put specific scenes out here. Like the Alamo, of course, the Riverwalk, it's a very beautiful city. It's a very photogenic city, to capture music videos and scenes out here.
So tell me a little bit more about being a videographer and what you do.
Being a videographer is a lot of fun. It's a lot of fun, like I'm able to travel a lot and God blessed me with the opportunity to pick up this craft. It took me a while, to pick it up. And
Object to non-responsive.
oh, okay. Sorry.
Hold on.
Objection will be sustained. You may proceed.
Okay.
defense.
So how long have you been doing that line of work?
Honestly, since I left high school. I graduated in 2015, so I want to say I've been doing music since I was like 10 years now, but on the videography side, I started getting interested in like 7 years ago. About 7 years ago.
And was that when you lived in Houston?
Yes.
Okay, so there's been a lot of testimony about different artists and their names and what they reference and what they mean.
Yes.
So tell me a little bit about the culture surrounding the people that you work with in their music.
Well, no, with that, it's out of my control because, they want specific things in their video because they want to portray that lifestyle. And, well, I have to go ahead and record it, And so, with some of them, of course, you got cars, jewelry, women, and of course, you got that lifestyle that people occasionally do drugs. They have, their guns, and that's on whatever they want me to film, at the time, that's what I'm gonna film.
And when you do work, do you create an environment that's free of any type of distractions?
Object to relevance, Your Honor.
Sustained.
When you do work, how are you making sure that you're staying professional?
Object to relevance, Your Honor.
Overrule. You can answer.
Okay, so the way I keep professionalism, I make sure that I stay sober minded. I do not, first, I don't like smoking at all, so I stay sober minded 24/7. And I make sure that the safety of the premises are okay, like I tell the rappers to take the clips out of their guns, make sure their guns are on safety, like I just make it very comfortable and very professional because my work is my work and it's my work.
Okay. All right, I'm approaching with lip and mark for identification purposes only as defendant's exhibit 5. All right, do you recognize what I've handed you?
Yes.
How do you recognize it?
Because I put my name on it in the date,
Oh, and what is it?
and it's a USB.
Okay, and so you've reviewed the contents of the USP? You're
Uh,
familiar with the contents of it?
Yes, I am familiar with it.
Okay, and just generally speaking, what does it show?
It shows me. On one of the videos, it shows me working. I was
Okay.
literally out here in San Antonio,
Okay,
and I set up a scene. You know, I set
Okay.
up. Yeah.
and I'm gonna offer defendants exhibit 5 at this time.
I'm objecting to hearsay, Your Honor.
All right, if the parties could approach.
A lot of labels and vlogs. You know, like us. Some of these rappers they do shows, so I go to the shows and I record the shows and I put it together. Just like recently, I had gone on tour with Mexican OT, and so it's just one of those things that I do.
Do you also do content creation?
Yes,
And what about photography?
yes.
The date of this incident, October 27th, 2024, is that what you were doing in San Antonio? Okay, so tell me a little bit about that. Well, what was the plan to do here in San Antonio?
Eat that night, and we were supposed to go to like a hibachi place, and we did. Mr. Paul, he wanted me to go ahead and record. You know, it's a hibachi. You know, it looks cool. You know, everybody's cooking. You know, and experiencing a little shrimp, and so that's what we're gonna do. And afterwards, we're gonna have his girlfriend drive down here. Like I said, San Antonio is a very beautiful city. So we're gonna be around the boardwalk, just taking photography, or of course Halloween. You know, his girlfriend was a model at the time, and probably still is. But at the time, we were gonna do a Halloween shoot for his girlfriend, and just besides that, we're gonna go out to eat, record the vlog, and of course record the photography shoot.
So I'm gonna play you I'm sorry, State's Exhibit 4. I'm gonna start it at 1:19:11.
So just took us. I had they asked me to drive a car, right? Just came car. They said it was we drove from Houston, and we landed there. I took a nap right there.
Stopping at 1:19:28. So Felipe, what did you mean by it was supposed to be a clean car?
Meaning that there wasn't supposed to be any drugs in the car, like personal use, like because I don't smoke and I don't like being in a car full of smoke, which they usually call a hot box. And I don't like that because it gets very hard for me to breathe because I'm a big person already. So it's been amazing multiple occasions where I've been at a video shoot and there's been a lot of smoke and I ended up throwing up. So I just personally don't even like to be around that smell or even type of smoke.
Okay, so when you get the car, whose car is it?
This is Paul's car.
Okay, And where is Paul at this time?
Paul is in the other vehicle with the other gentleman in the Cadillac. And that's the reason that he was riding with him, because we're already heading towards the restaurant. And he was like, you know what, we're gonna smoke. I know that you don't smoke, so go ahead and ride another car
Okay, and so you get in the other car with who?
with the girl that she was gonna be driving.
And this girl, did you know her name?
Honestly, I hadn't even met that chick like 4 hours or 5 hours prior to the event.
Okay, and when you get in the car with her, does she enter the car at first with anything?
No, she did not.
Did she eventually go back into the house to get something?
Yes, she went to go grab that bag that they have in evidence.
Okay, and had you seen that bag before?
No, I have not.
And when she gets in the vehicle, what did she do with the bag?
She put it in the back seat. And honestly, I thought it was her personal belongings because I hadn't seen this bag. And like I said, I only had met this girl 4 hours prior, about 4 or 5 hours prior to the event.
And the bag, why did you think it was personal belongings?
Because it's the bag that we didn't have in the car when we came here. So I was like, hey, it's her personal belongings.
Okay, and so then when she gets in the car with the bag, do you ask her about it?
No, really, because I didn't really question it. I didn't really question it because I was like, well, she probably has her makeup, her bag, like I said, we're already ready to go to go eat and then go do a photography shoot.
So then you're saying that the Cadillac drove off and a Paul and the other guy drove off in a Cadillac, right?
Yes,
And then it was you and the girl. And from there you were supposed to go to a restaurant.
yes.
Okay, and what do you recall happening when you're driving with the female?
I remember just taking off and then I laid my seat back because like I said, I don't know how to say this yet, but I had fell asleep at the house because whenever I got in there, I was very tired of traveling. I had just got off tour with that Mexican OT and then 1501 for the Chapo, So I literally just fell asleep because I'm like, you know what, let me rest before I start shooting because I didn't want to shoot in it very tired. Who likes to go to work tired? So I rested, and then by the time I woke up, they woke me up and they were like, "Hey, we're ready to go. We're gonna go eat." And I'm like, "Okay, cool. Let's go eat." And I got in the car. She got in the car, and then she went back inside the house, grabbed the bag, put it in the back, and we took off.
What happened after that?
Like I said, I put my seat back, and I was been just chilling, and then next thing you know, I see lights and then I'm like, I thought it was a car behind us, thinking that it was the Cadillac. I'm like, oh well, they're gonna get pulled over, and so she continued to go, and next thing you know, we get to the light, and there's vehicles in front of us. Of course, there's a red light. When she decides to go ahead and take the curve, and that's when I realized that there was something wrong. And then she starts going at very high speed. And I'm arguing with her, telling her to stop the car. Stop the car. Like, why are you going so fast? And then she grabs the bag to the back seat, and she's just telling me, shut up." Like, dude, I guess I was annoying her with my questions. And she handed this bag. She told me to throw it out. And when I throw it out, she starts to argue with me.
Judge, I'm gonna object as to him testifying to what the female is telling him as to hearsay.
Hearsay, Your Honor, goes to the his response, not for the truth of the matter asserted, but rather his response in the situation, and it goes to negate the mental state.
All right, any other response with regards to an objection defense?
It also goes to negate that he acted intentionally in this case, or that he had any type of free will in committing any
All right,
incident.
objection is sustained.
Okay, so you, at this point, what are you feeling when she's driving?
Scared. I'm feeling very scared because I've never really been in this predicament ever. So I was feeling very afraid and just confused.
What was her response, or what did she do in response to you telling her to stop or slow down?
She got agitated.
Okay, so is she the one who grabs the bag to tell you to throw it out?
Yes.
How is she telling you?
Very rude and very loud. And very, like I said, she's pissing me out a lot. And once I threw out the bag, it was nothing but me, her going back and forth, telling me that that's how.
Judge, I'm gonna object again as to the hearsay.
Sustained.
Okay, so then the next thing we saw from the video is that the car ends up crashing.
Yes,
And when the car crashes, what do you feel?
afraid, and honestly, that's the most scared I've ever been. I just thank God that I'm alive, because he's giving me a second chance to life. Like, I could have died that
I'm
night.
gonna object as to non-responsive.
Sustained.
Sorry.
Okay.
No, God could take my life.
Okay. And
Sustained.
are you feeling any type of pain at this point?
Just emotional pain, from that night.
Well, when you get out of the vehicle, what do you do when you get out of the vehicle?
I just try to get out the vehicle just to make sure that I'm okay. And as soon as I get out the vehicle, that's when the police put their guns on me and just tell me to get down on the ground. First, they're very, very rude, calling me names. And I'm scared.
Objection, non-responsive.
Sustained.
So Felipe, let's move on a little bit. So where the crash happened, you get out of the car. Do you try to flee or escape the police? Okay. And you wait for them to give you commands, is that correct? Once you've been able to follow their commands and get on the ground, how are you feeling physically?
Hurt.
Okay.
Feeling very hurt. I'm feeling very hurt, but when you get in the back of the evidence of which I have gone before, they are very expensive.
Objection, relevance, and
Sustained.
non-responsive.
Oh, and are you thinking clearly at this point? Okay, and were you wearing your glasses at this point?
No, ma'am.
Where were they?
They were inside the vehicle. They have flew out of my face.
Can you see without your glasses?
No,
Okay. And did you indicate that to one of the officers that was helping you step away from the accident?
yes, I did. I told them that my glasses were inside and that I needed them. That they could please retrieve my glasses from the vehicle.
Did they?
No,
Did you ever get your glasses back that night at all?
no. I had to get my glasses when my mother bought them for 2 months without being. No,
Okay. Do you recall the initial officer asking what you were doing?
yes.
Do you recall what you told them?
I told them that I was in San Antonio to record a vlog, and then we were gonna go eat, and then we're gonna take some photos, and that's the only reason that I was in San Antonio.
Okay. Play defendants for at 119:28.
Whatever business they have going on, is their business, you know what I'm saying? And then when we're about to leave, they gave me a badge, it was under my seat. And
when you say that, I'm sorry to cut you off, man. When you say that, who's they? What do they go by? What's their name?
I don't know, I just know one dude, and that's it, his name's Nate, I just know Nate.
Nate?
I just know Nate, yeah.
Which one is he? With tattoos or without tattoos?
With tattoos.
Okay.
You
He's the one that has tattoos all over
yeah,
his face?
yeah, he's in the hand, he's got my car gun. I was in San Antonio, and they just gonna stay over here, and then we're gonna go get some meat over there in Austin. When we have a clean slate, you know what I'm saying? And I'm like, okay.
Did you owe him some petty or you owe him some money?
No, I needed some extra bread money, you know what
So
I'm
you
saying?
should see him keep it.
I don't know, but that was a discussion talk, we got to Austin, you know?
Mhm.
We're gonna go back to Austin
Okay, stopped it at 1:20:22. So when you tell the officer we were supposed to go to Austin and then have a clean slate, what did you mean by that?
Meaning that our final trip to our videography in our blog, taking pictures. Our final destination was gonna be Austin because that's where they stayed at. And we're gonna spend the night there before we went back to Houston, where I originally had my house is at, my house.
And what did you mean specifically by once we got there, like we'll have a clean slate?
Meaning that I don't know how many pictures I was gonna take or how long the session was gonna take. Usually I charge by how many pictures or depending how many hours we're out there. Or even where I'm gonna go shoot at. Sometimes I go to Dallas, sometimes I go to Oklahoma, just depending how far the travel is. That's what I meant. by
Objection,
clean slate.
non-responsive.
Sustained.
And so when you say I just needed some extra rent money, you were expecting to get the money from the shoot. Is that
Objection, leading.
Sustained.
where were you expecting to get the extra rent money that you referenced?
From the shoot because, like I said, this is how I only make my living. I don't have a 9 to 5, and I work for myself because I've been blessed to at least make enough money to pay my bills with this.
So did you have any discussions with these individuals about transporting any narcotics?
No,
Was there an agreement with them to transport or help them transport, even if it was in another car, any narcotics? And the narcotics that they are trying to link you with, the ones in the backpack, did you know about those narcotics?
I did not.
Okay. Had you seen what was inside the bag?
No,
And you said you didn't ask them.
I didn't. I didn't because I didn't think that Nate would put me in this predicament.
How do you feel he put you in this predicament?
Objection, speculation, calls for hearsay.
Sustained.
What do you mean by he putting you in this predicament?
Meaning that I allowed Nate to live in my house. And when I let him live in
Object,
my
I'm gonna object to relevance.
Overruled. You can answer.
I let Nate live in my house, and when he didn't have a job, when he didn't have nowhere to stay, and so I thought he would never put me in this predicament, meaning that you think that someone that's grateful for giving you a house or something like that will put you.
I'm gonna object to non-responsiveness.
Sustained.
Okay, and then in the video, you tell the officer that none of the stuff in the bag has anything to do with you, correct?
Yes,
Okay, what did you mean by that?
what it means that none of this stuff had to do with me, like, I didn't have no acknowledgement what was inside the bag, and I didn't know what was inside the bag until I heard some officers talking about it outside the car vehicle.
What were they saying about it?
They were-
Objection calls for hearsay.
Sustained.
Judge, this is important because it's not for the truth of the matter asserted that they did find the contraband, but rather his response, and it goes to provide context to why he's telling the officer about specific instances of items in this bag.
Sustained.
Okay, and so the officer tells you, he kind of cuts you off and he just tells you, well, actually, it does have something to do with you. Do you remember that?
Yes,
Okay. And then you responded to him, well, now it does because I threw the bag, correct?
yes,
Okay, but when you threw the bag, did you know what was in there?
no, I did not,
Okay, why did you throw it?
because me and her were going back and arguing back and forth, and she was just being very rude, and so at that point, I'm like, fine,
So,
that's why the bag didn't fly so far because I just didn't care about the bag,
and when the officer's asking you whether you knew the contents and you say, I just know there was stuff inside, at Is it at this point that you're realizing that there
Yes.
is something in there?
Yes,
Okay. And then you told the officer probably pills, ice, on top of my head, that's all I know.
yes.
And why did you supply him with those specific items?
Because usually in the music industry, when rappers are talking about drugs and now, especially nowadays.
I'm gonna object as to non-responsive, Judge.
All right, that objection will be overruled. You can answer.
Like I said, nowadays, these days, these rappers in the music industry.
Well, Judge, I'm gonna object as to relevance as to rappers in the music industry.
All right, that'll be overruled. You can answer the question.
Like I was saying, these rappers these days, you guys hear it in the radio these days. All they talk about is sex, money, and drugs. And most of these drugs, throughout the years, they have become addicts. So most of these rappers either talk about, popping bars, they talk about, sipping lean, they talk about, smoking weed and they just talk about things that are gonna give them a body high. So
So I'm gonna object as to non-responsive.
Sustained.
Felipe, what are bars?
bars will be, it really, I could say depends because you don't really understand what it is, like lyrically.
So the officer mutes for quite a bit of time when he speaks to you. And you've seen the video.
Yes.
Do you recall what he was talking to you? He said that he was talking to you about being a confidential informant. Was he talking to you about that when he muted?
No, man.
Did he offer you the opportunity to work with work as a confidential informant at all during that conversation?
No, man.
What do you recall him telling you during that conversation?
Objection calls for hearsay.
I'm gonna overrule that objection.
You asked a question.
What do you recall him telling you during that muted part of the conversation?
He was just basically telling me that I'm gonna be the one that's gonna get charged for the drugs and that how much time I'll be looking at.
Did he tell you anything else?
And basically just threatening me with just like I said, just the fact that I was gonna give like 75 years and that I'm the one that's gonna take the fall for it.
What did you say or do in response to that?
That's when I got very scared, and of course, hearing the fact that you can get incarcerated for 70, 75 years, that just gives a mental breakdown, and I was just very responsive in trying to get him to understand that those weren't my drugs, and
Okay, and so you were being honest with him?
yes, ma'am,
Did you think when you were speaking to him that he would help you?
yes.
How so?
I thought if I was just honest and being cooperative, that I'll be free and I wouldn't be being charged with these drugs, these charges, because simply I was just there to do a videography job. And I thought that Nate would at least man up to the charges.
Did you think he would believe you that you honestly didn't know what was in the bag?
Yes,
And then a few days later, you actually contacted the detectives asking for help, right?
yes, because I was like, man, I already know that these detectives were trying to charge me with this, and I didn't know if there was a warrant to my arrest, so I was like, I need my cameras. I need my cameras because this is the only way that I make a living is, and I don't have, like I said, I don't have a 9 to 5, and I'm about to go back, I was about to go back on tour, Mexican OT and FNF Chapo, and that opportunity just got taken away.
So did you think at that point also that they were gonna help you?
Yeah, so I thought they were gonna give me my cameras, because that's the conversation that I had with Officer Ramirez, I wanna say.
The dude that he was with the long hair.
I'm gonna object as to non-responsive, Judge.
All right, that'll be overruled. Ask your next question.
So Felipe, the warnings that we call in Texas, the Miranda warnings, that the officers read you about your right to remain silent and anything you say can be used against you. Did you understand those?
To a certain extent, I did not, because of the car accident. And I was shocked. And I just didn't really understand what the surroundings of my situation.
And I think when this Detective Robles asked you whether or not you understood your rights, you began to tell him something, correct?
Kept like, like kind of ignoring it, like, yeah, when you just hearing somebody talk, you're just like, yeah, okay. But in reality, I was just looking around to soak in the scene that was going on around me. Cause the lights, the police lights were going off everywhere. And just the fact that I didn't have my glasses, I wasn't really paying attention to that piece of paper.
Did you know that it was going to be used against you in court? What did you think you were doing by signing this paper?
Just helping them out because the detectives originally just showed me a paper and they were like, just sign this paper. Just tell me what's in the paper, just write it. And that's really about what I thought that paper was. Just me trying to help them out, trying to, let them get some information.
And when you said you had no knowledge of when the officers asked you to write the pill color and to write the amount of pills, you said you had no knowledge of that, right?
No knowledge.
Was that true?
Yes.
And why did you write down here weed?
Because that's the typical thing that rappers do, or any thing that's on the street. And that's the main thing that's out there, like, that from my knowledge, that people do.
Why did you write down here weed if when he asked you, you said maybe I'll just put it in there?
Yeah, because that's exactly what at that moment was happening. He said, we, I'm like, yeah, okay, let's just put that in there just in case.
Okay. Why would you do that?
Because I was trying to be very cooperative, with them.
What your caregiver, Tammy Richardson, talked about in here the other day about you having dyslexia and having trouble kind of staying on task and understanding things. Is that true?
Yes, yes. I had to take a lot of classes as a young kid just to learn how to read properly. And when I discovered that I had dyslexia, they gave me a blue paper, like a blue sheet, or I guess that was my color. They have multiple colors that certain people with dyslexia they can read with, and I've been dyslexic since we discovered it. To be honest, I was dyslexic before. It's just not something that you just get out of nowhere. You just born with it.
Okay.
Um,
And is this your first interaction with law enforcement?
yes, ma'am.
Okay. Do you have any criminal history?
No, I don't have no criminal history in the States. I just only in the United States.
Pass the witness.
State.
Mr. Reyes, so it's your testimony that in the year of 2024, you did not have a 9-to-5 job, is that correct?
I did not.
Okay, and so you were doing content creating and photography to make a living, is that correct?
Yes, ma'am.
Okay. Now regarding Miss Tammy Richardson, isn't it true that before coming in here to testify for you, you hadn't seen her in over a year?
Yes.
Okay. And isn't it true that you discussed with Miss Richardson that regarding your Instagram page, your excuse for your Instagram page being spelled correctly is that it was done on a phone, and it was done with autocorrect, is that correct?
Yes.
Okay.
it is.
And so moving on, you stated about the music culture and that you work with a lot of rappers, correct?
Yes.
All right. And so you mentioned Mexican OT, is that right?
Yes.
All right. And Mexican OT, he's a famous rapper right now. He's pretty popular, you would
Yes.
say. Okay, and he is an avid marijuana smoker, correct?
To my knowledge, yes.
Okay, and he smokes marijuana at his shows.
Yes.
Okay, and you've worked those shows?
No.
No?
No.
And when you're around him, has he smoked marijuana in front of you?
Of course, yes.
Okay, so you're familiar with the odor of marijuana.
I do.
Okay.
But those shows are outside, and every time I had an interaction with him, it was mostly outside.
Okay. And so you stated that the weekend of the offense on October 27th, 2024, you were down here for photography, is that correct?
Yes.
All right.
And
And
yeah,
so-
a vlog.
And a what?
In a vlog, we were supposed to go out to eat that day, and we were supposed to record, and also too, if my lawyer would have been allowed to.
I'm gonna object as to non-responsive.
Sustained.
Please just answer the questions that I'm asking you.
Sorry.
Okay, so you stated that typically you work with rappers, right? When you do vlogs? Okay, and vlogs, are they like videos that are posted on YouTube?
Yes,
Okay,
and Instagram, TikTok, Snapchat, any social medias.
okay, thank you for that clarification. And so the people that you came down here to shoot for, they weren't rappers, is that correct?
They were not,
Okay,
but like I said, came to shoot a vlog for them, and also for his model girlfriend.
okay, and so what was the content gonna be?
Like I was going out to eat, and then of course me taking pictures of the model, and I was gonna vlog it at the same time, but I'm taking pictures of her.
Okay, and so was the model and was the model the female that was in the Nissan with you?
No,
Okay, so there was no other female in the Nissan or the Cadillac, so where was this model?
she was in Austin. She was gonna make her way down here.
Okay, so she was gonna come to San Antonio from Austin,
Yes.
and then you were gonna drive up to Austin?
When we're done with the shoot, we're gonna spend the night there, and then drive back to Houston the next morning.
Okay. So on the weekend of October 27th, 2024, what day did you drive down to San Antonio from Houston?
So it was 27, so I wanna say that night. Yeah, I really wanna say that night we drove.
Okay, and when you arrived here in San Antonio, you went to the residence on Hidalgo Walk, is that correct?
Yes, so if that's what it says, yes, because I'm not from San Antonio, so I don't know the streets.
Okay. About what time did you arrive in San Antonio?
See, I would say it was like around 5 or 4 o'clock.
Okay. And so it's your testimony that you were asleep in the home on Hidalgo Walk
Yes,
until y'all left?
yes,
Okay, and so when you said in your statement, whatever business that they have going on, do you recall saying that?
yes,
Okay, and you mean the packaging of narcotics inside of the residence at Hidalgo Walk, correct?
yes.
Okay, and so you were aware of what they were doing inside that
No,
residence?
I did not. But what I meant, what kind of business is like at that point, the officer already had told me.
I'm gonna object as to non-responsive.
Sustained.
Just please answer the questions I'm asking you. Do you understand?
Yes,
Okay. Now, moving on, you said that you really don't like being in the presence of marijuana smoke or the odor of marijuana, is that correct?
yes.
Okay. Um,
I'm gonna ask you to put these on, please. State's exhibit number 7, I believe. Can you go ahead and smell that for me?
I really don't wanna hold that because I don't, is it okay?
Which I'm gonna object to her asking him to take a whiff of that package. He's not even familiar with it. It's not been established that he's had any previous familiarity with that package.
With regard to him smelling the package, that objection will be sustained.
Okay, well, you're familiar with the odor of marijuana, correct?
I am familiar with that.
Okay, and you can smell it coming from this package, isn't that true?
Yes.
Okay. Now. You stated to the officer in the statement that the backpack was under your seat, but you've since changed your testimony to it was behind the female, is that correct?
Yes.
Okay. And so you testified that when the officers initiated their red and blue lights, the female continued and took the curb onto Brady Boulevard, is that correct?
Yes.
Okay, and your testimony was that you feel blessed because you weren't hurt in the car crash, is that correct?
Yes.
But you're aware that other people were,
Objection to
correct?
relevancy.
Right. With regards to relevancy, that will be sustained.
And you stated that you only suffered emotional pain that night?
Objection to relevancy.
And he
Overruled.
testified to it.
That objection is overruled. You can answer the question.
Yes, but also too, I got physical pain. It wasn't just, I got PTSD from that night, but not only did I have a seatbelt trauma, so my stomach, it was subject to the seatbelt being on me, and that's what the hospital records say. And the fact that my head got banged up because the car had got it really, it was a small vehicle and I'm a big guy.
Okay,
And
And
I
so
got
you
a
were
few
taken-
scratches right here too. I don't know if y'all can see, but I got a couple scratches still in my body that from that night because there was windows shatterings everywhere. And the windshield, of course, popped up from the front of the car.
and that's because the car flew into the back of a home and flipped over, isn't that correct?
Yes, ma'am, but I didn't have control of the vehicle. I
Okay,
wasn't the one driving.
Thank you. And you were taken to the hospital, correct?
I was taken to the hospital when I got to booking.
Okay, and you were released from the hospital shortly thereafter, correct?
Yes, I was.
Okay, and there were no notations of you having a head injury, isn't that true?
I don't know so what my medical records say, ma'am. I don't understand that stuff. But if it was on medical records, I mean, I don't know if there is in there.
All right. Now, you stated regarding Nate, he was your friend, right?
He was, yes. he
And
was a-
you provided him with a home in Houston, is that correct?
Yes, I let him stay at my house in my living room while he was getting himself back on his feet.
Okay,
But
and so he has no motive to make anything up about you, correct?
no, he doesn't.
Okay. And regarding the bars, that is Xanax, correct?
I remember that it was just lyrical bars. That's something that.
Listen to the question. Bars is associated with Xanax, correct?
In the music industry, yes.
Okay. Now. You stated in your previous testimony that you thought that if you cooperated and signed the voluntary acknowledgement of the methamphetamine and the pills that you would be let go, is that correct?
To my acknowledgement, whenever I signed that, I didn't have my glasses, so I did not see that the fact that methamphetamine was on top of the list. But since I was talking to the officers, and I was like, you know what, they were kind of guiding me to what's right on that piece of paper, because they were talking to me, they were like, oh, okay, yeah, let's go ahead and write that too.
Okay, but Detective Robles specifically asked you, do you agree that there was methamphetamine in the bag? And you said, yeah, you heard that, right?
Yes, because there were the officers outside of the vehicle, the police car talking about it, and
I'm gonna object as to non-responsive.
Sustained.
I'm gonna instruct you again to please listen to my question and answer it, okay?
yes.
Thank you. Okay, so it's your testimony and we see in the body worn cameras that you didn't have your glasses that on that night, correct?
Yes,
Okay, and so if we look at the voluntary acknowledgement that you filled out, we can see your name right here, correct?
yes,
And so you were able to write that without your glasses, correct?
yes,
And it's spelled correctly, right?
yes,
Okay. And then moving on to the other things that you wrote, the pills, you were able to write that and spell it correctly, correct?
yes,
Same thing for weed,
yes,
same thing for blue red,
yes,
same thing for backpack,
yes.
same thing for toss it window,
Window is not spelled correctly, man.
okay? And same thing for Nissan.
And Nissan is probably not spelled correctly, man. That's a B.
Okay. Well, you're sure quite the speller in here.
Objection, Your Honor. What's the question?
What is your objection?
There's no question. It's the
Right,
council's
Mr.
testifying.
Sutton.
Now, you stated that the bag was not in the car when you came here, is that correct?
Yes,
So you drove a clean car down here. Which car was that? The Nissan or the Cadillac?
that was Nissan, because that's Paul's car.
Okay, and so you drove that car from Houston to San Antonio.
I didn't personally drive that car. It was Paul that was driving that car, because Paul, I don't own a vehicle, so I have to get picked up from shoots. And, or I have to take Ubers, but since this was a very long drive, I'm not gonna take an Uber over here. I'm gonna drive the car.
So why did you state that you drove it from
But
Houston?
what I meant is that I was gonna say that we drove it over here, you know?
Okay,
But since I was in shock and everything, my responses that day went like not 100%.
but in the video, you stated that it was just me, myself, and I to the detective. Do you recall that?
Like it's just me, myself, and I. Like I'm talking about myself. I'm not talking about them. When I'm talking to them and I'm telling them that that's not myself, I'm talking about me, myself, and I. I'm not involved in any criminal activities, man.
So that was your response when asked about driving the clean car. You said it was me, myself, and I.
But
So why
at
would
the
you
time,
say that?
at the time, I wasn't understanding what he was saying.
Okay, and you never told anyone that Paul drove down from Houston with you, correct?
No, I did. My parents and everybody knows that I don't have
I'm gonna
cars.
object as to non-responsive. Did you ever tell an officer that you drove down here with Paul? You didn't, right?
No, not at the
Okay,
time,
thank
because
you.
at the time that was irrelevant.
It was irrelevant at the
It was
time.
irrelevant because the girl was driving.
So when you're saying that you're so scared, you didn't think that that was relevant? Wouldn't everything be relevant
I
at
said
that
I was
point?
scared multiple times, man.
So my question is, if you were so scared at the time, wouldn't it have been important to let the officers know that on the scene?
Objection to speculation, lack of personal knowledge. Ask for a
Overruled.
conclusion, legal
Because
conclusion.
it was irrelevant to the accident and to the scene that was going on at that moment. That Paul was driving the other car and the girl was driving this car, so it wouldn't be relevant for me to tell him that I had drove down to San Antonio with Paul. When the vehicle is already marked under Paul's name. So it's.
I'm gonna object as to non-responsive.
Sustained.
Moving on, let's talk about the female that was in the car. So you stated on direct that you're a big guy, so about how tall are you?
I am 5'9".
Okay, and how much do you weigh?
I weigh about, at the time I weigh about 380 pounds.
Okay, and the female, she was smaller than you, correct?
Yes.
But it's your testimony that you were scared of her because she was being rude to you?
Well, ma'am, I'm a very nice guy. And I grew up in a home where I had to respect women. I don't disrespect women, ma'am.
Okay,
And I'm very compliant, and so when it comes to some of women disrespect me, at the time, I'm very feeling emotional, like, why are you disrespecting me?
okay,
When I don't even know you like that.
okay. Do you think it was respectful for you to refer to me as fat in your jail call?
Objection of relevance, Your Honor.
Overruled.
You can answer the question.
I don't know you.
Why are you speaking about me on your jail call?
Objection of relevancy, Your Honor.
Overruled.
An objection to reference to discovery that has not been provided to the defense.
It's been uploaded to e-discovery.
No, it has not.
All right, so have parties approach. All right, ladies and gentlemen, I'm going to give you a brief, I say brief. Let's go off the record for a moment. Ladies and gentlemen, are you all okay with coming back at 11:45? All right, there's just some matters that needs to be taken up outside your presence. So remember my previous instructions, and then I'll bring you back in at 11:45. All right, everyone, please rise for the jurors. State with regards to the questioning of this witness, and sir, you can have a seat. With regards to the questioning of this witness, you said that these are jail calls?
Yes, that they were made over the weekend.
All right, so you're saying the calls that you're referencing were made this weekend?
Yes, Your Honor, between Friday after recess and yesterday.
All right, then if you'll let defense hear those calls.
Yes, Judge, if I may be excused just to get behind this.
Yes. All right. So we'll be in recess with this matter. Is there anyone present who has a client who's on bond? All right, so Mr. Rittenhour, if you will confer with the state and then come forward with your client. Anyone else have anyone on bond?
That one of my clients was in custody, Ashley Jones. She's gone.
Yeah. All right, is she on a PR bond or is she on a commercial bond? All right, if she's on a commercial bond, if you want to contact the bondsman, then I'll take that matter up. All right. And if anyone has anyone who's in custody. All right, thank you. Yes, and well, they need to hear the jail calls. So it's probably gonna take them a while to bring, yes. Yes. Oh, you have someone? Okay. Oh, just do, oh, we can do the plea today. Yes. Let's. Purpose. All right, thank you. All right.
Is it a CTD case? Pardon? Is it a CTD case?
Yeah. Three of them there.
All right, just have them,
Today's date.
bring your fine out. Well, let's see, let's have your guy brought out. All right, thank you. Have you asked them to pull your file? All right, just give me a moment.
See ya. Hello.
All right, who is on Terrence Scott and where is he?
He's here at the gallery, Your Honor.
He needs to come
Parents, stand up
forward.
for me, please.
No, he needs to come forward.
Mr. Scott.
She take out the drugs, you could smell it through the whole courtroom.
Yes.
It's, you could like literally smell it.
Oh, no, I can smell it as well. You're on this side, counsel.
You can have the loud.
Right.
All right. So on this case, where are we on discovery?
Judge, we were, this was for making sure the discovery had been complete. I have received the discovery. In fact, I used the brand new system the DA just looked to me, quite nice.
Okay.
I have that stuff right now.
All right, state, were you able to receive an offer from the state?
I have not yet, Your Honor. Y'all been in trouble.
All right, so you're gonna have to get an offer from the state. And sir, how old are you?
Let's see.
All right, Ms. Ferguson,
Yes, ma'am.
bring this for a plea deadline date, the week of June 23rd, please.
I can do the 24th.
All right, your plea deadline date is gonna be June 24th. Once you sign the reset form, you're excused.
Thank you, Your Honor.
All right, thank you. Like your shirt. All right. And if you can sign a discovery acknowledgement before you leave
I
council.
will, Your Honor, if they can get me one.
Sorry about the late, Judge.
Oh, no problem.
Remember. It was supposed to be the date.
Jason, can you make sure an offer is tendered to Todd Lessert on Terrence? Can you make sure an offer is tendered to Todd Lessert on Terrence Scott?
Yeah, I just saw him walk out. He said he's gonna come back to the discovery acknowledgement.
Okay, thank you. Everyone, please make sure your phones are off.
Oh, okay, yeah, you could smell it, like literally, like smell it right now.
Yeah, I'm getting a Okay. All right, who's here? Lawrence Cloud?
He's in a jury trial today in Guadalupe County, and he's got all the discovery and he's got the video for this.
All right, is he Clyde in custody?
Yes, and he wants to see it. I mean, if he gets out, I'll have him contact the court and we could just get a little, he's got all the material that we need to show the client before he makes a decision.
Okay. All right, you need to get an offer from the state.
Let's see if I have one.
And then,
Yeah, we have one.
oh, you have an offer?
Yeah, but he wants to see the materials, and we just uploaded the video and we have the
Ms.
discovery.
Ferguson,
Excuse me.
put this for a plea deadline date, the week of June 23rd, please.
And we'll try to get that done at the jail.
All right, June 23rd, the week of June 23rd, plea deadline date. All right, it's the 26th.
26th?
Yes,
June 26th?
yes.
Okay, thank you, Judge.
Thank you.
May I be excused?
Yes. All right, Deputy Laura,
You get a chance on my.
Cloud is going to be reset for June 26th for a plea deadline date.
I couldn't find you, did I? You waiting on that?
No.
All right, is the defense hearing the DVD? All right, thank you.
Well, we come in tomorrow. All right, tomorrow. You know even there, right? Yeah. Washington? Yes. Okay, great. Oh.
Are we gonna put the judge on?
Thank you very much. Have a good day.
Yeah, I think we just, the DA needs 2 weeks to look at something.
Yeah. On this, I don't see an affirmative finding of family violence. Michael Anthony Arojo,
So Roy, Judge.
Arroyo, okay. Come up.
This was the matter that there was a,
Yes, I remember it.
so do I.
All right, where is he?
So Mr. Arroyo is present.
Come forward.
Mr. Edelman is suggesting that he needs 2 weeks to review some video to confirm.
Recordings, it seems that there's main vehicle recording in the possession of SAPD that has not been produced. I have not had an opportunity in requesting it.
All right, so is that recording going to be something that tells us the person, the identity of the person driving the vehicle?
I don't know. I won't be able to say whether. And that's why I want to have it in order to review it to see what.
All right, Ms. Ferguson, recall this for June 16th.
Thank you.
Thank you. Once you sign the reset form, your excuse.
Put on today's docket?
Yes, it should be. Yes.
You want to do that reset?
This Wilson has got 3 cases. I need to approach the judge.
I just never do like this. Old man or old man. Serving something? Sure.
Yes.
All right, Curtis Wilson,
This judge.
where is he? Yes, counsel.
Judge, I believe we're set for a pretrial hearing today.
Yes.
I've lost some internet in my office, so I can't confirm that you even received the motions.
I'm sorry, what?
I lost my internet, and I'm all digital. So when that happens, I'm lost.
All right, we can recall it for tomorrow for motions.
Okay.
All right, Ms. Ferguson. Wilson is being recalled tomorrow for pretrial motions. All right, just have a seat. They're gonna give you a reset form. Once you sign it, you're excused.
Trial court certification for Larry Smith. Please. Larry Smith. Please. Yeah, Leroy, how about Leroy?
Because it's always meant to check me out.
Can I have that print out? Thank you.
That's all it was. Thank you.
You just covered it.
Oh.
Who's here? Larietta Holmes?
Good morning.
Good morning.
Judge, we're here this morning just to set a bond. It's a deferred case. The MTR right now is set on Thursday. I checked with probation this morning. They don't have the report ready yet, but hopefully we'll be able to resolve it Thursday. There may be a small chance I may need some more time depending on, I'm trying to get some information for us.
All right. So you're requesting a bond?
I want to see if we can get a bond set.
All right. Have you conferred with the state?
I have
All
spoken to
right.
Jason.
It's calling 2024 CR 2336. Everyone needs to whisper. State versus Larietta Holmes. Can I have parties announced?
Jason, do you have to state your own?
John Robertson from his Holmes.
And are you Ms. Holmes?
Yes.
All right, defense is requesting a bond. You're on deferred adjudication, so you're entitled to a bond. Have you all reached an agreement on a bond amount?
No agreement, Your Honor.
All right, state, what are you requesting for a bond amount?
Previously, the bond was, Your Honor, and the state is requesting 30,000.
All right, defense, what are you requesting?
I request court to consider 5,000.
Do you want to call your client as a witness for purposes of the bond?
Sure.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. You're gonna need to speak up so the court reporter can hear and so I can hear.
Yes, ma'am. Larietta Holmes.
All right, defense, you may proceed.
And Ms. Holmes, you're in custody pending a motion to enter adjudication of guilt on the case, right?
Yes.
Okay. Before you were arrested, were you working?
Yes, I
What,
was.
what kind of work were you doing?
I'm a licensed esthetician.
And do you also receive any other type of assistance?
Yes, sir.
And what is that?
I received SSI's, benefits.
Okay. And if the court were to set a bond in this matter, you understand that would potentially, if you're able to make the bond, we would still have to come back to court for the motion to enter adjudication of guilt. Do you have funds available to where you could post bond?
Yes.
Okay, understanding that at 10% that the bondman might be necessary, do you have funds available to post a $30,000 bond?
Not 30,000.
You have funds available to post a $5,000 bond. Is there any other family assistance that you would be able to rely on to come up with money to post bond?
My spouse and my,
That's all I have.
All right, any questions, state?
Yes, Your Honor. Previous bond was at 15,000, is that correct? And did you make that bond?
yes.
And why was your bond, why were you remanded with that bond?
Honestly, I don't know. I just remember it's not bond. And they just came to pick me up.
What further question, Your Honor?
All right, this is what the court is gonna do. The court is gonna set your bond at $30,000 and there's to be no contact with the elderly or the complainant in the new allegation. All right, Ms. Ferguson, if you give a reset form, please. They will be back on Thursday,
I think we're already set Thursday, Judge.
but she doesn't have a reset form. I want to make sure she has one.
And Judge, if we need more time, can we address the court on that on Thursday?
Yes.
Thank you.
Ms. Abrams, on Holmes, she was just here for a bond setting, but her hearing is actually on Thursday. All right, who's here on Paul Marceau? Yeah.
Do you need Mr. Marso?
Yes. All right, have you conferred with the state?
We have, Judge.
And do you have all discovery?
We thought we did, Your Honor, but spoke to Mr. Garahan, there's a note on the file about there's an EDU disclosure on one of the officers that we don't have yet. Garahan's gonna get that to us.
All right, Ms. Ferguson. This is gonna be recalled back for July 7th for discovery update. Mhm. All right, other than that, is there anything else that's missing from discovery?
Nothing on that, no, not on that case, Judge.
All right, and then he has a motion to amend bond conditions to allow for travel. State, are you objecting?
Your Honor, at this time, from the facts of the case, I don't have an objection, but I have not been able to contact the complainant to see if she attends that church or is around that church. We
All right,
just,
so this is an narrating arrest, detention and vehicle. That's what I have. Is there something?
There's another case, Your Honor, that's unindicted still.
All right,
I filed a motion in both cases, Judge.
all right, could I see the motion on night mag number 701641, unless you have a copy?
That one, right? And it's for travel. It's a bond modification so that you can go to church, Your Honor.
All right, and state, you're gonna have an objection?
no, we do, because we haven't been able to contact the complainant to see if she attends that church. There is a no contact order in place. Which I just haven't been able to confirm that. This is the first time.
All right, when do you want this set? When will you have the information and we can set it for motion to alter bond conditions?
Your Honor, if we could just maybe call it back later this week. I've already sent out the call and email to.
All right, you want to come back on Thursday?
Yes, Judge.
All right, Norma, recall this for June 5th for an update on the bond issue. And then at that time, I'll give them, well, I've already given them the date of July 7th for discovery. All right, and then the bond matter will come back on Thursday, June 5th. So if you can
June
give them a reset form, please.
Thank you, Judge.
He doesn't have an objection. Order.
Yes.
Thank you.
Thank you.
Thank you, Your Honor. May we excuse?
Yeah,
pending-
would you sign the reset
Thank you.
form?
Thank you. Your
Thank you.
Honor. Well, can I take that motion back? Is that okay? Sorry. I just want to keep it's.
Yeah, but if you'll make sure that they have it next time
Will
with
do,
the
Judge,
clerks in
will
the
do.
back.
Yeah,
Okay.
sorry, Judge.
All right, thank you.
Yeah, we want to approach on Mr. Payne and Silva. Um. we can do that two more time. I don't. Just for us. After the.
All right, who's here on Roger Blanco? And where's Mr. Blanco? Come down, please.
Have two motions, Judge.
All right, so are you requesting a withdrawal?
I am requesting a withdrawal, but I would first like to hear before I withdraw, just a motion to set. I'm not on the first degree list, Judge, and this got filed as habitual.
All right, so then I can't go forward with any other motion. It's gonna have to be the motion to withdraw. Then we'll appoint an attorney to represent him.
Okay.
And they can hear the remainder. All right, so the motion to withdraw is granted. Sir, just have a seat. We'll make sure you get an attorney.
And I'll go ahead and find out who it is and I'll.
All right,
cover
thank
that.
you.
We have a seat, Judge.
Yes. Oh, we're gonna give him an attorney today.
Okay. Thanks.
All right, Norma, he needs an attorney. And we have attorneys who are here, so that's a good thing. Mr. DeLeon?
Anything I can do to assist the court.
We appreciate it.
It's for Adriana Rollins. She got on top.
No problem. All right, Mr. DeLeon, let us know when you want that brought back.
How about Tuesday, June 10th, 1 week from tomorrow?
All right. Norma, put it down for June 10th.
That's your.
Got it.
Tuesday. A week from tomorrow.
Deputy Laura, what page? Oh, there he is. Deputy Laura Blanco is coming back on June 10th.
We did, we see a little bit of air, but it's starting to go away.
Well, I've never smoked marijuana, so I have no idea that you just have to air it out. I thought, you know, Febreze.
No. Oh, just have to air it
But
out.
Febreze doesn't work. We have not gone nose blind, obviously.
But you felt it.
I did.
Here.
All right, Norma, Adrian Ramos recalled for June 9th.
Speaker.
All right, Adrian Ramos. They're gonna recall you back on Monday. Your attorney is currently in a jury trial in another court. All right, thank you for dressing appropriately for court. Once you sign the reset form, you're excused. Thank you. You're welcome. Who's here on Jonesha Walker? All right, if you come forward. Where's your client?
I'm not Judge. I'm here for Elizabeth Russell.
Okay. Hello, why were you late for court?
I was here.
No, you were not. No, you were late. I called your name. You were late.
I was outside the courtroom.
All right, so court is inside. So court starts at 9 o'clock.
Yes, ma'am.
And you need to make sure you're here. Otherwise, a warrant's gonna be issued for your arrest. Do you understand?
Yes, ma'am.
All right, so where are we, state on discovery on Janesha Walker? I don't know if this is criminal trial division or family violence.
It's CTD, Judge.
Thank you. Yes.
I'm not sure because I'm covering for Elizabeth Russell, but we did get our first offer today.
Okay. How old are you?
29.
All right, Ms. Ferguson. Set this for a plea deadline date on July 7th.
Yes, ma'am.
Thank you, Your Honor.
All right, once you sign the reset form, you're excused. Thank you.
Thanks, Judge.
Very good. There is discovery that's been available to.
All right, thank you.
Thank you. I know I'm breaking. Oh, you did?
I haven't had it.
Okay. That's what it was in the process of doing today.
All right, who is here on Malik Lampkin?
Your Honor.
Because we need to get an update to the courts
Okay,
from the Center for Healthcare Services. Those people are here.
all right, so what is happening with that? Hi. Hi.
I'll let you talk.
Oh, so I did talk with Molly, last week, right? About last week. And he does meet criteria for substance use disorder. And he did tell me that he was agreeable to go to full time if that was an opportunity that he would have. So. Yes, he does meet criteria.
All right, so,
Have him there by this week, next week at the latest, but there are some beds available right now.
all right, so this is for the motion.
It is supposed to be for the motion to revoke, Judge, but I don't think the state and council have had an opportunity to work that new case out. So we would ask that this, if we move forward today with the lifetime recovery, that be added as a condition of his bond.
All right, so we can add the, like, has he made bond on the new charge or no? Have we made bond? I think maybe he's talking about the hold on the motion to revoke, because if he's on a deferred for that, then he may have a hold. So if you want to talk to or with the state, thank you so much for being here with your update and everything. I truly appreciate it, and moving things quickly. I like that. So if you can speak with the state, then we can see about setting conditions of bond. And you say lifetime?
Yes, ma'am.
And then we'll set the bond with the condition that he go to lifetime recovery to address the mental health as well as any other issues.
My understanding is that if he's out on bond, if he's at lifetime recovery, he'll be brought back for all his court dates.
Okay, all right, if you can confer with the state
I
on
will.
that, and then we'll take care of it.
All right.
All right,
Thank
thank
you.
you. And are they also here on Mr. Payne?
Yes, on Mr. Payne, so Vanessa,
Can I see the file on Payne?
Mr. Payne and Ms. Silva.
So
Not yet.
Yes.
Okay,
Yeah.
so I did talk with Mr. Payne, and we were in process of getting him a screening with ACOG that's in the jail. However, when they went to go visit with him, he was in the hospital. So we're gonna have them meet with him. I just sent them an email letting him know that he'll be over there sometime today or tomorrow.
All right, Mr. Payne. Hi, if you can come up for me, please. How are you doing this morning? Good morning. How are you doing? Oh, thank you so much. So they said they came to see you, but you were in the hospital. Are you doing okay?
Yeah, I have so much, where did I go to hospital? When I had a seizure, in clinical observation, for the first time I ever had a seizure.
All right, so when do y'all think you'll be able to see him?
I'm gonna try to see if they can see him this week. We also did talk with his brother, which his brother said that he was willing to have him come back under some certain conditions as far as him being stabilized back on his medications again, which he also agreed would be good for him. And then, but also to have that follow-up care as well. So his brother had given me the names of all the medications that he was on, and he was on that injection that usually lasts about a month. So we're in the process of reaching out to university within the jail. And I also brought some people from Corazon Ministries that are helping me.
Thank you so much. Oh, come on up. So what I'm wondering then, can we recall it for maybe next, 2 weeks? And then if we're gonna recall you in 2 weeks, okay? But if they have information for you before the 2 weeks, they can come in anytime and we'll put you on the docket anytime.
Yes, ma'am.
All right, so what date are you all thinking?
Well, we're in the process right now, but I know that, here, Russell. Yeah, so Russell had this great idea, and we
Yes.
talked to Mr. Payne as well, and he was also agreeable to work with True Mental Health if we can get everything sorted out. So then we're just trying to figure out that part. So along with the ACOG services, because they can also help brother and him and also do like in-home visits, but True Mental Health also does that stuff too.
Well, what I can tell you all is I'm not gonna be here the week of June 16th because I'm doing a CLE. But if y'all wanna do something, I don't know if you can do it by Zoom. Yeah, we can do it. I can put him down for June 23rd. Mr. Payne, if they have everything worked out before June 23rd, all they have to do is let me know and I'll figure out a way to make it work.
Okay.
All right, I tell you what, let's do this. If everything is worked out before June 23rd, since Judge Rangel does the mental health court, which I know he doesn't qualify for, I'll ask Judge Rangel if he'll hear this matter since he has mental health court experience.
Love that idea.
All right, so we're gonna put you down for June 23rd.
Okay.
Ms. Ferguson?
Yes, ma'am.
Mr. Payne, we're gonna call him back for June 23rd, but if they have everything completed before then, and if it's completed the week of June 16th, I'll ask Judge Rangel if he'll hear it.
Yes, ma'am.
All right, is there anything else?
No, ma'am.
All right, thank you so much. Continue doing what you're doing, okay?
Yes, ma'am.
And take care of yourself.
Okay, thank you.
All right, thank you.
Judge.
Thank you guys so much.
Bye, guys.
Miss Silva, maybe very similar.
All right, let's bring up Miss Silva. Could I see the file on, oh, here she is. Oh, I have it. It's on Silva. Hi. Okay.
morning.
Good morning. You're looking healthier.
Thank you.
All right, so what's going on with Miss Silva?
So I spoke with Miss Silva last week, right? And so there is no She does not meet criteria for substance use disorder. She's been a long time, really proud of you for that. And so what we were thinking was also getting her screening with ACOG as well, getting her set up with that and seeing if we can get her back into another boarding home, right? That's what you wanted to do? Yeah, so they will help with that facilitation as far as getting her set up with that.
All right, so then what we'll do, we're gonna reset you for June 23rd. However, if everything is completed before then, if it's completed by June 16th, I'll speak with Judge Rangel and see if he can hear these two cases, okay?
Okay,
So-
if that don't work, could I please try going to the new group?
All right, so this is what I believe in. I believe in building bridges as we come to rivers. So we're gonna see what happens with this. So let's 100% focus on this. And if this doesn't work out, then we're gonna see about something else, okay?
Okay.
Now, just know if you come back on the 16th, they're not gonna bring you to this courtroom. They're gonna bring you to the courtroom across the hall, okay?
Do you know what number that is?
Hmm?
What number is that?
Oh, it's 379th. All right, thank you.
But we're talking about June the 23rd.
Yes, she's set for June 23rd, but similar to Mr. Payne, if they have everything done by June 16th, it'll be with Ron Rangel.
I have a quick question for Ms. Silva. Do you have identification and social security cards? I have, if I'm not doing it, only working tomorrow, we can go back. Okay. If you want, I can give you the address. But you've been here in very clear. All my life. Okay. So if anything, you know, as far as like safety net, right, like a backup plan would Russell with Clarkson would be able to try to facilitate that into Haven if we can't get another boarding home or anything situated. We'll figure something out.
Okay, right. All right, thank you.
Thank you, Judge. Thank you,
Thank you. Thank you all so much. I appreciate it. We can't do this without you guys. All right, does anybody know if Defense Counsel has completed reviewing the jail calls? All right, if someone could check to see if they're done, because the jurors coming back in at 11:45. All right, thank you.
Because when we approach on a matter that's set for tomorrow.
Oh, just give me 1 second. They need to pull the file.
Right. But it says for tomorrow. But we'll be.
All right, who's here on John Thornart?
Hi, Your Honor. Morning.
Good morning. Good morning. All right, so you're actually scheduled for a jury trial.
That's right. And Judge, really quickly, I'm sorry to cut you off, Your Honor, but this was also about receiving discovery. It was a setting for that.
Yes.
I did retrieve the external drive this morning.
Mhm.
Just talking to Mr. Edelman. I had not gotten any type of notice beforehand. I'm not saying that that's an issue with the state. I just had not received anything like that, but it was there waiting for me. So I have not yet reviewed it, Judge, but but I do have it in my possession now.
So you need time to review?
I do, Your Honor.
How much time are you asking?
At least 2 weeks, Judge.
All right. Ms. Ferguson,
Yes, ma'am.
set this for, you want to do it the week of June 23rd?
Sure.
All right, could you set this for the week of June 23rd, and that'll be final discovery?
Either day is fine.
All right, so you'll come back on June 23rd, and that will be the final discovery date.
Yes, ma'am.
All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you, and I appreciate your time. Good day.
All right, you too. Number, what page is he on? All right, thank you. And Mr. Thornhart, you need to make sure you're on time next time.
Yes, ma'am.
And I'm sorry, Your Honor, he was outside. I had him wait. I do apologize for that, Judge.
All right, let him know it needs to be inside.
Sorry about that, ma'am.
No problem. All right, thank you.
Don't know how to work.
Yes.
Yes. What's your case?
It's on Ashley Jones.
All right, you need to have them pull the file.
Okay.
All right, once they pull it, I'll call you in order. Okay. All right, Roger Blanco?
That's me, Judge.
Yes.
Yes. Judge.
Right. You want to have a hearing on the bond motion?
Yes, this is his, I just got appointed to his case. He was on a $10,000 bond. Mr. Aguilera, his previous attorney, his home burned down on 170 Peach Valley,
All right, we'll,
and it was returned for,
okay.
it was shown that
All right, court is calling 2025 CR 002-804, State versus Roger Blanco. Can I have the parties announced?
Jason Garrett here from the state, Your Honor.
and Michael Doleon for Mr. Roger Blanco.
And are you Mr. Blanco?
Yes, ma'am.
All right. It appears that the defense attorneys has filed a motion to have a bond hearing. And the defendant, I'm assuming his bond was revoked because he didn't appear?
That's correct, Your Honor. He didn't have notice of it and, but he will make all his court appearances and
Yes.
he hasn't had any problems
All right,
beyond this.
Mr. DeLeon is saying that the defendant didn't receive notice because the house burned down. And so the documentation that his previous attorney, Mr. Aguilera, had was that this address is listed as a vacant lot. So is there a agreed amount per bond or no?
I haven't discussed with anything with Mr. Garahan, but his previous bond was 10,000. We just like to have it set again for 10,000.
And he. All right, and state, do you want to see the indictment?
If you don't mind, thank you, Judge. Thank you, Judge.
State, do you have a bond amount you're requesting?
If the previous bond was 10,000, Judge, the state would be requesting a minimum of $20,000 bond.
All right. Any objection? I'm assuming there's no objection to the court reviewing the indictment.
No objection to that, Your Honor. In the alternative, we would ask for compromise of 15,000 potentially.
And do you want to call your client or no?
No, Your Honor. I think everything's put out in the motion.
All right, then the court will set your bond at $20,000 with all previous conditions. And can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Roger Blanco.
All right, Mr. Blanco, and this is just for purposes of me setting conditions of your bond. Have you ever had any type of mental health issues in the past?
No,
Ever been diagnosed?
never.
Ever been on any type of medication?
No, ma'am.
Any type of drug use in the past?
Yes.
All right, and in the past, what would that have been?
Heroin.
All right, this is what the court is going to do. The court is going to set your bond at $20,000 with all previous conditions. The court will add 90 sober meetings in 90 days.
Yes, ma'am. Still legit.
All right, and Ms. Ferguson, if you'll give him a reset form, please, for June 10th. All right, thank you.
Thank you, Judge.
You're welcome.
Thank you, miss.
You're welcome. Or whatever his previous setting was, I think June
June
10th.
10th is
Yes.
correct, Judge.
The defendant, yeah. All right, thanks.
Yeah, thank you. I appreciate it. Thank you.
And we'll work on it.
All right, who's here on Malik Lampkin? All right, no problem. Ashley Jones.
Oh, just we wanted to let him know already on Medellin.
Good morning, Judge.
Good morning. All right, where's Miss Jones?
She is not here, Judge. I called pretrial services. The same phone number, there's no answer. I called the bondsman. They gave me two phone numbers. One I already had, and the other one I left a message. And I don't have a response yet.
All right, the court is calling 2025 CR 002136 State versus Ashley Robin Jones. Could I have parties announced for the record? State.
Austin stops the state.
Defense.
Alma Benavides for Ms. Jones.
All right, this hearing was scheduled at 9 a.m. It is now 11:41 a.m. The court called the docket at approximately 10:40. The defendant did not answer docket, and the court has called this case number as well, and the defendant has not answered docket. Deputy Laura, did you make an announcement for Ashley Jones?
Yes, I did. She is.
All right, defense, have you had any contact with your client?
No, I have not, Your Honor.
All right, state.
Your Honor, we're asking for her bond be forfeited on these cases.
All right, that will be granted, and your client will be remanded without bond. If she makes an appearance, the court will reconsider.
Okay, thank you.
Thank
Judge.
you.
Thank you, Judge.
Thank you.
I'm back on Lampkin.
Yes.
Army up there? An NPR.
Who is him? Byram Mejia?
Judge President, yes. Judge, this matter is set for tomorrow. It's a brand new case. There is voluminous amounts of material. Some material is maybe inappropriate, so.
All right, is your client on bond?
He's in custody.
All right, so what amount of time are you requesting?
I guess another 30 days. The goal is to go see the first tranche of information tomorrow afternoon, maybe 30 days or something.
All right, Ms. Ferguson, I need a 30-day reset.
I can do it the July 7th, Judge.
All right, July 7th.
Thank you, Judge.
All right, thank you. You're welcome.
Maybe just the 8th. I'm sorry, I didn't realize this one's out of town. So the 8th would
Right,
be.
July 8th.
Thank you, Judge.
You're welcome. All right, are you ready on Malik?
Yes, Judge.
Lampkin?
Judge, I've conferred with Mr. Garrahan
Mhm.
and Mr. Garrahan was going to recommend a particular bond for the NTR.
All right, so does he have any bond on his current case, the 2025 PF 10415?
Yes.
You do?
Yes.
All right, so
that is 100,000.
all right, and has he already made that bond? All right. And then on the motion to revoke, what are you requesting the bond? I think he has a bond set on this, doesn't he?
I believe that's the one that, Mr. Dillon was trying to get a bond set.
All right. And have you all come to an agreement or no?
I have a recommendation of $75,000.
All right, so We can go on the record, but Mr. Lampkin, it appears that you're on deferred adjudication for a specific offense. And then this new case is a higher level of the same offense. So I don't see why. And I'm assuming that's based upon what's in violation of condition number 1?
Yes, sir.
All right, so this may be improperly submitted or placed in intake because violation of condition number 1 says theft from a person.
Yeah, and then they also, I believe that they had also, on the NTR, also put it as a robbery. I haven't had an opportunity to look into that, Judge, but obviously one's a second degree, one's a, big deal.
All right, so counsel, I know that they already say they have a placement for your client, but do you want to recall this so that the state can look into what perhaps you all can work out as far as the bond placement?
That's a good idea, Judge. Let's do that. I haven't had that opportunity because I'm not even sure if the case is indicted yet. It feels like it wants to be indicted, but
Okay.
I do need to look into any discovery the state would provide to us if they feel.
All right, so Mr. Lampkin, the placement is still going to be available. It's not going to go anywhere. And the people who are working with you are still going to work with you. But for me to set this bond, it would probably be best for you if the state and defense can communicate with each other, which I know they will, because they're people who communicate with each other, and come to perhaps maybe agreement. Maybe they can come to an agreement, maybe not. And then that perhaps could fast track you to where you need to be, which is in an inpatient facility, okay? What day?
How about a week from tomorrow?
All right,
Maybe I can get everything I need by June 10th.
all right, Ms. Ferguson, can you put this on June 10th?
Yes, ma'am.
All right, and Ms. Abrams, if you'll let them know that this is going to come back on June 10th. All right, thank you.
All right, thank you, Judge.
You're welcome.
Additionally, Judge, I've got one other client today, Leroy Smith. It's gonna be a plea, Judge. I can't be back this afternoon. And then can we recall it for tomorrow? Can I do the
Yes,
plea
and
tomorrow?
who is the person?
Leroy Smith?
I'll just have them pull the file.
Yeah.
Don't be talking.
All right, who is here on Michael Medellin?
Yes, one Judge.
1:30.
Thank you.
Well, you know what, Norma?
Yes.
Put them at,
They're still working. They're having trouble with the printer as well.
all right, put them at 1:45.
1:45.
And he's here for sentencing, correct?
Yes, correct, Judge.
All right, the court is calling 2024 CR 011692, State versus Michael Medellin. Can I have parties in this?
Orlando Gustanion for defense.
And are you Mr. Medellin?
Yes, ma'am.
All right, counsel, we're here for sentencing. He entered a plea of guilty. The state waived count 2. There was a PSI and TAP evaluation report prepared. Have both parties had a chance to review the PSI? State?
Yes.
Defense?
Yes, Judge.
Any objections?
No, Judge.
All right, the state is recommending deferred adjudication. Is there anything you wish to say on behalf of your client?
So I did read the pre-sentence investigation report. My understanding is that there was, I guess, a scheduling of for a mental health evaluation assessment. My client understood that that was voluntary or optional. And so he did not attend that. Part of that recommendation I saw in the PSI.
Well, I note that the request is for a PSI and TAP evaluation, I believe. Maybe after they completed the TAP evaluation or interviewed him with the PSI, then they wanted to see about a mental health evaluation.
Right. And so I don't think he's opposed necessarily to have that evaluation done, but I think at that time he was saying, well, I thought it was optional. And so he did not go to that scheduled event. In regards to the pre-sentence investigation report, I understand that there's some recommendations in there. I believe that the he's admitted to consuming alcohol and consuming cannabis. But it does not seem as he's consuming either of those on a daily
If you
basis.
drug tested today, what are the results gonna be
No,
for everything?
no, just the, material.
All right.
And so, it was saying in
Is
the,
that with a prescription?
Excuse me?
Is it with a prescription?
No, you're on.
Okay.
that the, recommendations when the, TAF values for DDRF, I don't believe that it's necessarily appropriate at this point. One, there's no evaluation, but it also says if not accepted in that program to do a SATIF or ISF, one of those, and because of the usage, the level is not high. We're not talking about other substances outside of those two. I believe that more appropriately an outpatient program would be, I think, more appropriate. And we'd ask that you just follow this plea agreement. The complaining witness in the pre-sentence investigation report did say that she did not have a problem with the plea agreement. She's not seeking, there's not any restitution. She also said that she wasn't injured. And I believe that this is a fair agreement. We just ask that you follow it.
All right. Are you employed? You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
You can lower your hand, state your name for the record.
Michael Anthony Medellin.
All right, and Deputy Laura,
Yes, Judge.
they can start going back. We're gonna bring the jury in after this. All right, what do you do for work?
Right now, I don't have a job here.
How do you support yourself?
Right now, I'm doing freelance, but also retaining or getting help from my mother and my girlfriend.
All right, so you need to stop getting help from your mother and your girlfriend if you're gonna be using marijuana. You understand?
Yes, Your Honor.
Do you have any children?
I have one on the way, Your Honor.
Okay. And marijuana smells bad. You understand that?
Yes, Your Honor.
So you shouldn't be smelling like marijuana so that your child doesn't end up smelling like marijuana. When children are born, their brains, they're being developed, right? And their brains are developing. So doing all of these outside things, drugs or anything of that nature, that negatively impacts the development of the brain. You understand?
Yes, ma'am, I understand.
All right, so this is what the court is going to do. 8 years deferred adjudication, restitution, and no contact with Samantha Sandoval. If they say there's no restitution, there will be none. Regular reporting by Zoom or in person, regular random UAs. I want levels tested. If the levels increase, motion to revoke is going to be filed. I'll start with intensive outpatient treatment. There's be a $2,000 fine that will be prorated. Proof of employment within 45 days. There should be no employment as a home health care provider or with minors. There's going to be 200 hours of community service restitution. 100 hours to be deducted upon completion of the healthy relationship course. And the remaining 100 hours once parenting classes are completed. Field visits 1 time per month until further notice. There's to be 60 sober meetings in 60 days. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
I don't believe so, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue with something, let your probation officer know about it. If you feel as though they're not addressing it, you can always come back to the court to address it. You understand?
Yes, sir.
And you're gonna have to get a real job. And when I say a real job, I understand this is your dream, whatever you're doing, that's your dream. But your child can't go from paycheck to paycheck, or maybe you have a job, maybe you don't have a job. You understand?
Yes, sir.
All right, good luck to you.
Thank you.
You're welcome.
Judge,
Hmm?
is this the original?
Yes.
Okay, you're retaining the copy of this?
No, I have an original as well. There are 2 originals because they don't have any trial court certification forms.
Okay.
So I
see.
have
didn't
mine
notice
as,
that. Okay.
yeah, so I
didn't
have mine as well.
recall. Thank you, Judge.
You're welcome.
May we be excused?
Yes, you may be excused. All right, so defense, you've had a chance to review the videos, the jail calls. All right, Mr. Reyes, you need to take the witness stand.
Judge, to have a motion heard on the record, however, in light of the
Oh, we can go on the record. We're on the record in the state of Texas versus Felipe Reyes. Defense, you wanted something placed on the record.
yes, Judge. Timely disclosure of the jail calls actually violates several of Felipe's constitutional rights, namely his right to a fair trial, his due process rights, and his rights to the effective assistance of counsel, because attempting to review 14 jail calls during an hour recess is not sufficient time for us to essentially change what our defensive strategy is going to be and then give our client proper legal advice. And even if we did see that these were uploaded, they were uploaded this morning. The trial started at 8 a.m., which again is not enough time to review 14 jail calls if we had gotten notice that they were uploaded this morning. And we also didn't receive an updated discovery acknowledgement till 11:39, which, if we recall, is during the time of the break. And under Hardin versus State, the court used 3 factors to determine whether the state acted in bad faith when they failed to disclose evidence. The first factor was whether the defense can show that the state intended to deceive. We believe the state knew that, or Ms. Galloway knew that she's going to use these jail calls prior to this morning, waited to upload them until this morning, and then waited to see if we would advise Felipe to take the stand, and then chose to use those jail calls against him.
All right, so here's my first question. My first question is, were these jail calls made by your client?
Yes,
And were these jail calls made over the weekend?
yes. Friday and Saturday, which she would have had enough time to upload these prior to this morning. I think the untimely disclosure is that they waited until this morning.
All right, no, here's my question though. These were jail calls that were made over the weekend, is that correct?
Yes,
All right. Did you inform the state before 11:40 or whatever time it was? Did you inform the state you were going to call him as a witness?
yes, we did. We
No,
gave
no,
them
no.
notice prior to 11:40 this morning. Yes, we did.
No, we took a break and defense counsel informed the court and the state that they needed to approach because they needed to make a decision on whether or not your client would testify.
Judge,
Now,
he's
so here's
already
my-
testified. He's been on the stand this entire morning.
No, what I'm saying is, did the state know that your client was going to testify before today? That's either yes or no.
Yes, we said that we may call him as a witness. We
No,
said that on
may.
Friday.
Did the state know that you were going to call your client as a witness today? That's my question.
I'm sure
Not
that they
maybe.
had an inkling.
No, not a maybe. Did they know? Did you tell the state, hey, by the way, we're going to call our client as a witness today?
No, Judge.
All right, so then the question becomes with regards to jail calls. If the jail calls were made over the weekend and the state is giving them to you today, then you have them today. And state, any other things you wish to address?
Judge, just not, I have no way of knowing whether they were gonna call the defendant or not. The calls were uploaded prior to the break. Research already stated they were unsure whether they were gonna call him or not. They weren't because it was smooth procedure. These calls were made, between the dates of 5:30, 25 after we recessed from court. And so after 6:30 p.m. and then up until 6/1/2025, which was yesterday, Saturday. So I did upload them as soon as possible, and it's for about 1 minute.
Judge, may I respond, please? I would like to finish making my argument. So the second factor under Hardin versus State is whether the state's notice left the defense adequate time to prepare. We did talk about how we were not given adequate time to prepare because, again, we were only given an hour to review jail calls, 14 jail calls. And then the last factor is whether the state freely provided the defense with information. arguably, I don't think that they freely provided us with the information. We, as defense counsel, only get an email when discovery is uploaded. Oftentimes that disclosure is delayed. And it would have taken a minute for them to come up to us and tell us that they were going to use those jail calls. And then also, again, we didn't receive the updated discovery acknowledgement until 11:39 this morning.
But if you're not calling your client as a witness, then the jail calls will not be used.
Judge, we are under no obligation to have to inform them. Under 39.14, the
that you're
state
calling-
is obligated to inform us of whenever they are going to use evidence, which includes the state's witness
But
list.
didn't they upload the discovery? And he is
They
not,
uploaded-
obviously, your client is not on the state. Did you have him on your witness list?
No, I'm.
All right, so they would not have your client on their witness list. So this is what the court is going to do. The court is going to allow the state to continue with their cross-examination. Then I will give you all a break to review any more weekend jail calls that your client is alleged to have made.
Judge, then the motion's for mistrial at this point because there is
It's
information.
denied.
And I'm just putting this on the record for appeal purposes, Judge, to protect everybody. But there is information in this that would have essentially caused us to take a different approach to our defense, including calling our client as a witness. And this was a late delay, which was bad faith by the prosecutor. And so I don't know how it's conscionable that we're proceeding with this trial when there is essential information in there that would have caused us to go a different route with our defense strategies.
Oh.
Had we known that information, we would have been able to better prepare for our defense and redirected ourselves this morning. And they've essentially prevented us from doing that, from doing our job, from being effective assistances of counsel for Felipe Reyes, because we're just getting this information now.
All right, so.
And the damage is already done by us calling him to the
So
stand.
state, any of the jail calls that you're questioning this witness about, are those jail calls that were made before the weekend?
No.
All right, so what we're gonna do, your motion for a mistrial is denied. We're gonna bring the jury back in, state you can consider, continue your cross. We'll take a recess, and defense, you can look at and review more of the DVDs if you so choose.
Judge, and then I asked that the prosecutor not be able to, or she needs to correct her statement in front of the jury, because what the call actually says in reference to her question about, is that why you called me fat? What it actually states is he is trying to talk to Miss Tammy Richardson.
That's what that is for your redirect if you should choose to do that.
I'm not gonna use that audio CD because it does, but that portion of it I think needs to be clarified, because she's misrepresenting to the jury what he actually said. What he actually said is they're trying to differentiate which female attorneys here at counsel's table he is talking about. And then
All right, so that is something for you to clear up on redirect if you so choose.
I can't clear it up without using the CD, and me using the CD opens it up to having the state using the entirety of the CD.
All right,
It's
so-
contradicting itself.
All right, so we're gonna bring the jury in.
All right, for the jury.
Oh, please be seated. All right, everyone, please be seated. State.
Mr. Reyes, could you acknowledge that your Instagram account, the name is Fat Vision Film, correct?
Yes,
Okay, and you do have that tattooed on your arm, correct?
yes.
Would you roll up your sleeve and display that to the jury?
I'm not object to this, Your Honor, to him showing any part of his body that's not covered.
All right, so what is your objection, your legal objection?
To relevance, to more probative.
All right,
And
with
more
regards to
prejudicial than
relevance.
probative.
Judge, there's still a link to the Instagram account.
It's already been established, Your Honor.
All right, that objection will be sustained.
We have to let this go.
All right,
Okay. Felipe, the prosecutor asked what you meant by.
state, and defense, if you can approach. All right, defense, you may proceed.
Thank you, Your Honor. So the prosecutor asked what you meant by whatever the other individuals were doing inside the house was none of your business. Remember that?
Yes,
And then she asked if they were packaging methamphetamine for distribution. You remember that?
yes, I remember what you said.
And you said yes.
I mistakenly, I didn't understand the question, and, no, that answer would be no.
If you were sleeping, then you never saw what they were doing inside the apartment. Is that right?
Never saw,
So why are you agreeing with her?
I misheard the question and I misunderstood what she was saying, I was blocked off for a second.
Pass the witness.
No further questions.
All right. Is this witness excused?
Yes, Your Honor.
All right, you may step down. Defense, call your next witness.
We rest, Your Honor.
All right, state. Defense, do you close? All right, both parties, if you could approach. Going to read to you what's titled the charge of the court. You don't have to memorize it. You'll be giving this original when you begin your deliberations. Members of the jury, the defendant Felipe Reyes stands charged in count one of the indictment and cause 2025 CR 0007000 with the offense of possession with intent to deliver a controlled substance in penalty group 1B, namely fentanyl, which by aggregate weight, including any adulterants or dilutants, was of an amount 4 grams or more, but less than 200 grams. The defendant, Philip Reyes, stands charged in count two of the indictment and cause 2025 CR 0007000 with the offense of possession of a controlled substance in penalty group 1B, namely fentanyl, which by aggregate weight, including any adulterants or dilutants, was of an amount 4 grams or more, but less than 200 grams. Both of these offenses and cause number 2025 CR 0000700 are alleged to have been committed on or about October 27, 2024 in Bexar County, Texas. To these offenses, the defendant has pleaded not guilty. The defendant, Philip Reyes, stands charged in count one of the indictment and cause number 2025 CR 0000701 with the offense of possession with intent to deliver a controlled substance in penalty group 1, namely methamphetamine, which by aggregate weight, including any adulterants or dilutants, was of an amount 400 grams or more. The defendant, Philip Reyes, stands charged in count two of the indictment and cause 2025 CR 0000701 with the offense of possession of a controlled substance in penalty group 1, namely methamphetamine, which by aggregate weight, including any adulterants or dilutants, was of an amount 400 grams or more. Both of these offenses and cause number 2025 CR 0000701 are alleged to have been committed on or about October 27, 2024 in Bexar County, Texas. To these offenses, the defendant has pleaded not guilty. 1, our law provides that a person commits an offense if he knowingly possesses with intent to deliver a controlled substance listed in penalty group 1. Our law provides that a person commits an offense if he knowingly or intentionally possesses a controlled substance listed in penalty group 1. Methamphetamine is a controlled substance listed in penalty group 1. 2, our law provides that a person commits an offense if he knowingly possesses with intent to deliver a controlled substance listed in penalty group 1B. Our law provides that a person commits an offense if he knowingly or intentionally possesses a controlled substance listed in penalty group 1B. Fentanyl is a controlled substance listed in penalty group 1B. 3, by the term possession is meant actual care, custody, control, or management of the controlled substance. Deliver means to transfer actually or constructively to another a controlled substance, regardless of whether there is an agency relationship. Adulterant or dilutant means any material that increases the bulk or quantity of a controlled substance, regardless of its effect on the chemical activity of the controlled substance. 4, a person acts intentionally or with intent with respect to the nature of his conduct or to the result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to the circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. 5, cause number 2025 CR 0007000, count 1. Now, if you find from the evidence beyond a reasonable doubt that on or about on October 27, 2024 in Bexar County, Texas, the defendant, Felipe Reyes, did knowingly possess with intent to deliver a controlled substance in penalty group 1B, namely fentanyl, which by aggregate weight, including any adulterants or dilutants, was of an amount 400 grams or more, but less than 200 grams, then you will find the defendant, Philip Reyes, guilty of the offense of possession with intent to deliver a controlled substance in penalty group 1B, namely fentanyl, which by aggregate weight, including any adulterants or dilutants, was of an amount 4 grams or more, but less than 200 grams, as charged in count 1 of the indictment in cause number 2025 CR 0000700. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 1 in cause number 2025 CR 0000700. 6, cause number 2025 CR 0000700, count 2. Now, if you find from the evidence beyond a reasonable doubt that on or about October 27, 2024 in Bexar County, Texas, the defendant, Felipe Reyes, did knowingly possess a controlled substance in penalty group 1B, namely fentanyl, which by aggregate weight, including any adulterants or dilutes, was of an amount 400 grams or more, but less than 200 grams, then you will find the defendant, Felipe Reyes, guilty of the offense of possession of a controlled substance in penalty group 1B, namely fentanyl, which by aggregate weight, including any adulterants or dilutants, was of an amount 4 grams or more, but less than 200 grams, as charged in count 2 of the indictment in cause number 2025 CR 0000700. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 2 in cause number 2025 CR 0000700. 7, cause number 2025 CR 0000701, count 1. Now, if you find from the evidence beyond a reasonable doubt that on or about the October 27, 2024 in Bexar County, Texas, the defendant, Philip Reyes, did knowingly possess with intent to deliver a controlled substance in penalty group 1, namely methamphetamine, which by aggregate weight, including any adulterants or dilutants, was of an amount 400 grams or more, then you will find the defendant, Philip Reyes, guilty of the offense of possession with intent to deliver a controlled substance in penalty group 1, namely methamphetamine, which by aggregate weight, including any adulterants or dilutants, was of an amount 400 grams or more, as charged in count 1 of the indictment in cause number 2025 CR 0000701. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count one in cause number 2025 CR 000701. 8, cause number 2025 CR 000701, count 2. Now, if you find from the evidence beyond a reasonable doubt that on or about October 27, 2024, in Bexar County, Texas, the defendant, Philip Reyes, did knowingly possess a controlled substance in penalty group 1, namely methamphetamine, which by aggregate weight, including any adulterants or dilutants, was of an amount 400 grams or more, then you will find the defendant, Philip Reyes, guilty of the offense of possession of a controlled substance in penalty group 1, namely methamphetamine, which by aggregate weight, including any adulterants or dilutes, was of an amount 400 grams or more, as charged in count 2 of the indictment in cause number 2025 CR 000701. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 2 in cause number 2025 CR 000701. You're instructed that unless you believe from the evidence beyond a reasonable doubt that the statement introduced into evidence was freely and voluntarily made by the defendant without compulsion or persuasion, or if you have a reasonable doubt thereof, you shall not consider such statement for any purpose, nor any evidence obtained as a result thereof. You are instructed that under our law, no evidence obtained by an officer or other person in violation of any provisions of the Constitution or laws of the state of Texas or the Constitution or laws of the United States of America shall be admitted in evidence against the accused on the trial of any criminal case. Therefore, if you believe or have reasonable doubt that any statement made by the defendant and offered as evidence was obtained in violation of any provisions of the Constitution or laws of the of the Constitution or laws of the state of Texas or of the Constitution or laws of the United States of America, in such event, the jury shall disregard any such evidence so obtained. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about these cases. You may not use any electronic device or media device, such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X, to communicate with anyone, any information, or receive any information from anyone about these cases, or to conduct any research about these cases until I accept your verdicts. Written statements made by a witness to investigators or other police officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in these cases. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in these cases, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with these cases, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in each case. After argument with counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict in each case, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court which is hearing given to you and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in each case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you in these instructions, you will acquit him and say by your verdict not guilty. Suitable forms for your verdicts are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdicts must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictments in this case, and you must restrict your deliberation to the issue of whether the defendant is guilty or not guilty and nothing else. After you retire to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any questions you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. State, are you prepared to proceed?
Yes, Your Honor.
All right, each party will have 20 minutes for closing.
Now it does have something to do with me because I threw the bag. Ladies and gentlemen, at the conclusion of this trial, now we all know what the defendant knew on the date of the offense and as he sits there today. And that is that he was knowingly in possession of methamphetamine and fentanyl in the charged amounts with the intent to deliver. Now let's talk about the law that applies. I'm going to differentiate by cause number. So we're going to start with a case that ends in 700. There's a count 1 and a count 2, but most of these elements are not in controversy. Okay, on or about October 27th of 2024, you heard multiple witnesses state that that was the day that they surveilled the house on Hidalgo Walk. They saw the defendant exit that residence and enter the passenger side of that Nissan Rogue. You heard multiple witnesses testify that this offense occurred in Bexar County, Texas. The location at Hidalgo Walk, the location at Brady Avenue and Couples, that is all in Bexar County, Texas. The defendant, Felipe Reyes, that's not in controversy. You've seen him, in the back of the yard on the residence of Brady Boulevard and giving his statement. So I'll come back to the two highlighted in red, a controlled substance and penalty group 1B fentanyl, not in controversy, and the aggregate amount for between 400 and 200 grams, not in controversy. we'll talk about knowingly possessing and with intent to deliver. You all heard Mike Franz testify from the lab that the fentanyl did come back at 30.248 grams, and it was positive for fentanyl. And then the cause number ending in 701, the same arguments except with the methamphetamine and the over 400 amount. And so you all heard Mike Franz testify that he received state's exhibit number 6 from SAPD. And you can look at state's exhibit number 18 and see that those substances were sent over by somebody at SAPD to the lab, where Mike Franz then took it into his custody and performed this examination, which yielded 499.52 grams of methamphetamine. Now let's talk about the mental states. Intentional is defined as the defendant's conscious, objective, or desire to engage in the conduct. Knowingly is defined as the defendant being aware of the nature of his conduct or the circumstances that exist. I submit to you that both of those are met in this case. And we talked about this during jury selection. Okay, you are not required to be a mind reader. You are allowed to infer this information from the facts, the statements, and the circumstances that are surrounding the offense. So let's look at that. At a minimum, the defendant acted knowingly. Okay, and let's look at the facts that support that. Ladies and gentlemen, when I put state's exhibit number 7, which is that vacuum sealed marijuana bag, you could smell that in the courtroom. And so the defendant, being in possession of that backpack, knew that that odor, he testified he is familiar with the odor of marijuana. And so there's absolutely no way that he did not know that there was marijuana in that bag. Also, the weight of the backpack. State's exhibit number 6, over 2,000 grams of methamphetamine. That backpack filled with all those things is heavy, and there's no way that he did not know that all of that stuffed into that backpack was not there. Then we'll look to the statements that the defendant made. 1, I just know there was stuff inside of it, referring to the backpack, like pills and ice, which you all now know is methamphetamine. That's a street term for it. The backpack was under my seat. Well, ladies and gentlemen, he's since changed his testimony since he's had a year to come up with what he wants to portray to you all, because it's easy to Monday morning quarterback when you know that you're going to be facing a jury of your peers. But what he stated to the police on that day was that the backpack was under his seat when he retrieved it and threw it out of the window, as you see in state's exhibit number 3. There shouldn't be no more dope in the car, just that bad. That goes to knowingly. When y'all lit up the lights, I had to toss the bag. Ladies and gentlemen, this goes to the defendant's consciousness of guilt. He knew exactly what was in that bag, and he knew that if he was pulled over and that bag was found under his seat, he would still be sitting in that position that he is today, because he was in possession of the methamphetamine and the fentanyl. Now let's look at the facts that support the intent to deliver. This further goes to the defendant's statements. In addition to the physical evidence that you saw, which is the scales that had residue, which is proof of what was going on in that residence at Hidalgo Lot, they were weighing it, placing it in the freezer bags for distribution. I needed the extra money. Again, easy to Monday morning quarterback when he gets up here knowing that he's going to face y'all and say that it was for content creation. We were going to discuss it, the money, when we got to Austin. So that backpack was actively being transported to Austin when that car crashed into the residence on Brady Boulevard and put a stop to that. Now, the defense wants you to believe he came down here to San Antonio to work. His statements were not voluntary. Detective Ramirez wrote meth on the acknowledgement. Well, let's look at the evidence and what the evidence supports. I don't dispute that the defendant did come down here to work. That's maybe one thing I can agree with the defense on. But his work was to transport narcotics. He drove a clean car down here. You heard Detective Robles testify as to what that means. A clean car means that it has all the paperwork necessary so that it is not going to be detected by law enforcement officers. Defendant's statements were voluntary, and you have those statements and evidence, and you can review them yourself. But he's read his statutory warnings advising him of his right at least 2 times. He acknowledged that he understood the rights. He states that he knows that there was frozen ice in the backpack. And even Miss Tammy testified that the defendant understands words when people help him. And the detectives did help him on scene. Now, it is true that Detective Ramirez did write methamphetamine on the form. And Detective Ramirez was captured on all of the video body worn cameras that are in evidence, and you can keep track of him in those state's exhibits. The word methamphetamine came from the defendant's mouth to Detective Ramirez's ears, and that's how it ended up on the paper. Okay, because after the defendant makes these voluntary oral statements, that is when the written statement comes along. And you heard Detective Robles asking, do you agree there was meth in there? And the defendant's response was yes. Now, your sole duty at this time is to consider guilt or innocence and nothing. And so, what are not defenses that are in the jury charge? These are not defenses that he suffers from dyslexia, and you don't need to know how to read to weigh stuff out and feel how heavy it is and to smell things. Okay, that's not a defense. Other people were in and out of the house. That's not a defense. He went to the hospital and he didn't put the bag in the car. Those are not defenses under the law. Ladies and gentlemen, the burden of proof in this case is beyond a reasonable doubt. State's exhibit number 16, which is that acknowledgement, proves each and every element of this offer. Okay. You are instructed that you are not to let bias or sympathy play into your deliberations. And you all took an oath to render a true verdict according to the law and the evidence. Ladies and gentlemen, there is only one verdict in that case, and that is guilty on all counts. There is an opportunity for justice to be had today. You heard the testimony that there were over 19,000 lethal doses of fentanyl, and that methamphetamine could have reached over 500 people in our community. Find him guilty. Your Honor, we reserve the rest of our time for.
All right, defense, are you ready?
I'm just 1 minute, Your Honor. I'm gonna go ahead and plug my presentation in. Members of the jury, there are 2 cases in this jury trial, 4 counts, but they only encompass 1 incident. Okay, there's a case for the fentanyl, and there's a case for the methamphetamine. And your options here for each case are either possession as a standalone, no intent to deliver, possession with intent to deliver, or not guilty. Same options for the methamphetamine case. Possession as a standalone with no intent to deliver, possession with intent to deliver, or not guilty. This isn't a case of multiple transactions or multiple days or multiple keepings of drugs. There's 1 incident, but they're charged as 2 cases for the different contraband. Okay. And so the burden of proof, as I mentioned during jury selection, rests on the state. And that's why they're going to get a chance to come up here and talk to you last. Because they have to convince you that they've proven all of the elements of this case beyond a reasonable doubt. So let's look at possession with intent to deliver. Remember that the difference between possession with intent to deliver and possession as a standalone is just that intent to deliver. Possession with a standalone doesn't have it, okay? So let's talk about mental state, because the state's right, that is highly contested in this case because to prove that somebody intentionally or knowingly possessed a controlled substance, you have to prove that not only did they intentionally and knowingly possess, but that they intentionally and knowingly possessed a controlled substance that they knew that they possessed was a controlled substance, a banned substance under our laws of the state of Texas. So intentionally, it's your conscious objective or desire to engage in this conduct, knowingly. Okay? Keep in mind that the state doesn't meet their burden by saying that, well, he should have known, or any reasonable person would have known that what was in that backpack is contraband. And they don't even meet it by saying that he was aware, but he chose to disregard it. Otherwise, the charge would include reckless or criminal negligence, because those are also culpability states under our law, but it doesn't have that. It says it has to be intentional or it has to be known. This case involves a higher culpable mental state. So don't rest your head on a conviction thinking that, well, he should have known or any reasonable person would have known, because that's not what the law applies in this case states.
I can't tell you exactly. I don't know. A description of what it was. With the color, what were they wrapped in? I can tell you, I don't know, I didn't see that. The color of the pencil? I didn't see that. How many pills, like, so that's what we get. You talk about green, if I'm getting 150, 100, I'm getting 100% honest, so like, I told y'all, I don't know what to talk about.
How do we know he didn't know what he possessed with the controlled substance? He tells officers over and over again he never knew what was in the bag. He knows what's in the bag after the fact because he hears officers talking about it. Because these officers are telling him what's in the bag. Because the people that he typically works with in this rap industry, these rappers and these hip hop artists from Texas, that's what they use. That's the drug of choice for these types of people. Pills, bars. Okay? He's not telling the officer that because he knows what's in this bag. He has no idea of what's going on, what's in the bag. And the female was the one that all of the officers who observed her coming out of the apartment and into the vehicle, she was the one who had care, custody, and control of the bag until she forced Felipe to throw it out of the vehicle, right? By force. You're going to do this. Do it right now. She's about to crash. She's speeding off. She's demanding. She's not telling him. So keep in mind that the actions in this case, they have to be voluntary, right? Felipe can't be guilty of a crime he didn't knowingly or willingly commit. He was forced to throw the bag out after the girl decided to go on a police chase right before she crashed to this house. He had no control over any of her actions. He wasn't the driver. And had she not forced him to throw that bag out, police still would have tried to pin the bag on any of the individuals there who would have let them. And in this case, that was Felipe. He was the weakest among the group of the individuals that they talked to. He was the most cooperative. The officer testified he took that as an opportunity. The most compliant, because he genuinely had never been in any trouble before. He testified he has no criminal history. He doesn't interact with law enforcement regularly. In contrast to these individuals who have. They were evasive. They were not compliant. They did not answer the officers' questions. And the officers took advantage of Felipe's cooperation and compliance in this case to charge him, to pin all of that contraband on him. So we're talking about Felipe's connection to these individuals, okay? He testified and his friend cooperated. His work as a videographer, a content creator who works with individuals in San Antonio, Houston, he takes photos, uses it for social media, what have you. And if you look at the shirt that he has on during his statements to the officers, it has his business name on it, Trap Visions. It has his business logo on it, his company brand name. And he had his equipment with him. Everything but his computer, his friend said, cameras, video recording equipment, everything, lights. His plan was to come here to work with these individuals to get content created for them. Okay, so don't be fooled when the prosecutor tells you that the money that they were talking about in that statement had to do solely with drugs and a job that he was supposed to do for them, okay? I need you all to be very, very open-minded, because when Felipe was talking about, he was supposed to, we weren't gonna talk about the cash until we got to Austin, it was supposed to be a clean car. He's talking solely about working with these individuals, okay? He told you, I don't smoke marijuana, I have to be clear-minded when I do these projects. I maintain a level of professionalism. That's what I meant by a clean car. And we hadn't talked about the payment because my payments are per picture, depending on the travel time. I don't know exactly how much work we really want done. It's cool. We do it and I get paid. That's what he's talking about. He told the officers that the plan was going to film contact while the group was leaving. And maybe one of these individuals that the officers talked to, the other suspects, maybe they even corroborated the work that Felipe was supposed to do with them. But we'll never know, because several of the officers muted their conversations with these individuals, and it just so happens that they don't recall much of anything else besides what Felipe told them, right? So if someone's not in exclusive possession, the state has to prove additional facts to link them to the contraband. So how does Detective Ramirez testify that he tries to figure out who possessed? He testified he looks at whether the contraband's found on their person, whether identifying documents or information is found with the contraband. He testified he found nothing on Felipe and no identifying information in the contraband to link it back to Felipe. And he also testified that he would never try to link possession to just one party at the scene, that he would never try to get one party to acknowledge possession. But that's exactly what he did in his case. Both him and Detective Robles forced a gullible and impressionable individual like Felipe to taking the blame for the contraband. And that's pretty much the state's entire case rests on the statements of Felipe, okay? The possession with intent to deliver. The only piece of information that Detective Ramirez used for Felipe was not only possession, but possession with intent to deliver. He testified it was the amount of the contraband and the scales. That's it. There was no evidence of any type of prior plan. There were no text messages showing who the contraband was going to, no baggies to divide smaller portions of contraband for sale, no showing of financials to corroborate any type of sales. Notice how Felipe had absolutely no knowledge of any contraband, much less an amount. He, on his voluntary acknowledgement form, he didn't include scales in that form. That's very important because it goes to knowledge again, right? Officer told him to write everything that's in the bag. He didn't put scales down on that form. He was completely clueless. And if he had no knowledge of the contraband in the bag, then he had no knowledge of the amounts or the scales, so he could not have intended to deliver. It's pretty easy to check this one off your list as not guilty. We talk about the amounts, right? The state said, well, the type of drug, the amount, that's not really in controversy. There's a problem with the methamphetamine. If you can see, the problem is that it's an item supplied and written in by Detective Ramirez. No indication Felipe definitively knew about it himself. So you can scratch methamphetamine off your list because Detective Ramirez knew that was wrong. That's why he told you when he testified on direct examination that he had Felipe fill out this form, and it was the defendant completely, entirely on his own. And then when I asked him and I confronted him with this image here, which already had methamphetamine written down on it, and I confronted him with that proof, he admitted that yes, he was the one who had written that, and he was just trying to help Felipe. I don't believe it. And the thing is that nobody asked him to help fill out the form. They wanted Felipe to admit everything so bad that they essentially told him what to put on that form. The problem with the methamphetamine and the pills is the officers aren't requesting Felipe say or write within the bag. They're demanding it. Listen very closely because they are demanding him to include information to them, to supply that information, to include it on the form. When he tells them he really doesn't know, they put words into his mouth, which he accepts because he thinks they're trying to get to the truth. And once he's done telling them the truth, everything's going to be all right. He testified to that. He said, if I was genuinely honest with them, which I was, they would believe me. I'd be able to go, I'd get my equipment, and understand. but that wasn't what happened here, right? And we know that Felipe believes that because we saw it with the prosecutor, when the prosecutor is asking him questions, trying to mislead him, trying to trick him. He's giving her everything that she wants. Yes. Okay. I was asleep, but yes, I guess they were manufacturing and distributing methamphetamine in the house. He doesn't know that he is this type of individual. He's not the brightest in the book. And Miss Tammy Richardson, who's known him since he was 7, told you that. Okay. She told you he's not very bright. He has issues holding jobs. He has issues passing tests. He has dyslexia. He's blind as a bat. The officers didn't go get his glasses for him. Look at that video very, very carefully because he's looking around. His face, he's disoriented. He cannot see. He's squinting. He asked the officers to what the form says. So whether or not his statement was really voluntary is also a question that's relevant to.
What pills in there? Was there any weed in there? Marijuana, weed.
And officers supplying him information. So your charge says that you can disregard a statement that was presented to you as evidence if you feel it was taken by violating a defendant's constitutional rights, meaning that it wasn't a voluntary and knowledgeable waiver. So if you believe that Felipe didn't fully understand that he was giving up his right to remain silent and obtain an attorney before giving any statement in this case, then you don't have to consider that statement. If you believe that they coerced him and fed him information and made promises to him of leniency just to get him to say what they wanted him to say against the law, then you don't have to consider that statement. The other issue is chain of custody, right? We didn't have anybody come in here and testify that they were the ones who picked up the drugs from the property room that was at the San Antonio Police Department. Nobody came in and testified that they received these substances at the crime lab because if you'll recall, Michael Franz just goes and picks them up when they're already there. Nobody came in to say that the substances the crime lab analyzed were in fact the substances that were recovered that night. You don't have any chain of custody before you can consider to validate that. And nobody came in to confirm that nothing had been added or exchanged between the items processed by Detective Carvaggio and the items the crime lab got. So the amounts. Initially, the officer in this case who processed the evidence testified that he suspected oxycodone or Adderall for the pills. And then Michael Franz came in and testified that he only tested one small pill or fragments from the whole. He couldn't say with any degree of certainty that the remainder wasn't fentanyl. And remember when he said he tested only one of the 5 bags of the suspected methamphetamine? You'll recall Detective Carvaggio's testimony. He said that when he field weighted the evidence, it came out to 2,098 grams. So if you divide that by 5, you get 419. And there's 2 reasons why that's problematic, because we don't know if the bags were all weighed out to be equivalent, meaning we don't know if they were all exactly 419. 419 grams is just too close to 399 grams. And you'll recall it's any element that they don't prove beyond doubt. So there was 399 grams in that bag. They have not proven this case to be beyond doubt. And I think that's a real question here. The other situation too is when you're dealing with these people, drug dealers, people who buy and sell this type of material, do we think they're being honest? Do we think they always put in that the drug that they're saying they're giving to you? I doubt it. Close enough is not good enough in this case. There are so many other issues with the state's case. So let's talk about the officers. One admits to not
5 minutes.
Another one would have passed off his own writing as that of the defendant if I didn't confront him about it. And these aren't just ancillary officers. These are the main officers in the case. This is the one who was charged with processing, tagging, photographing, and bagging all of the evidence that the state's case rests on. And this officer right here, he's the one who was in charge of the entire investigation. He made the charging decisions in this case. He was the one who got statements from everyone present and who admitted that it's possible that these very same individuals may have said something that could have substantiated Felipe's guilt. We'll never know because he decided not to have his body on camera. What we promised to. State has an issue with knowing involuntary possession, and they know that.
why they focused on it so hard, that's why they're gonna focus on it again when they come back up and talk about it. What they didn't deliver, that Felipe is guilty of possession with intent to deliver. We gotta think about this, who do we wanna help be held responsible in these types of cases? There's a lot of individuals. There's the kingpins, the sources, the transporters, the dealers, the users, and there's also innocent or naive bystanders. So while we understand that there's an urge to hold someone responsible for this contraband, that was law enforcement's job. They targeted and charged the wrong person in this case. So don't endorse their mistake by returning a verdict of guilty for Felipe.
All right, state you have 10 minutes and 52 seconds.
It is getting very difficult for Felipe to keep the story straight. I'm gonna go through a few of my favorite absurdities and contradictions. So the defense would have you believe that Felipe Reyes never had possession of this bag until the very moment when he was badgered into taking it and throwing it out of the window. But this is contradicted by his own statement. On Robles's body-worn camera, he states, when we're about to leave, they gave me a bag, and it was under my seat. They gave me a bag. His words, not mine, not Robles's, not Ramirez's, his. Defense counsel would have you believe that Mr. Reyes just went to San Antonio to perform his job as a videographer, presumably on a whim and a prayer, because Mr. Reyes plans to drive from Houston to San Antonio, then to Austin, with no real idea of where he's going to shoot, how much he's going to shoot, what he's going to charge, or who's going to pay him when he's done. This is his business. Been doing it for 7 years, at least. Now, perhaps he is truly that poor of a businessman, and yet he's so good at what he does that he goes on multiple tours with multiple recording artists. No, he's not that bad at what he does. He was there for something else. He needed extra bread money. And because he needed extra money, he made a poor decision. And that poor decision has serious consequences. Mr. Reyes would have you believe that he didn't drive that vehicle, that it was Paul. This is contradicted by Mr. Reyes' own statements. Yeah, pardon my language, not the dirty shit. I had the clean car. The gray car was clean when I drove it down. You know, because it was just me, myself, and I. He drove the vehicle. He wasn't driven, he drove. And that's his statement. Not mine, not Ramirez's, not Robles's, his. Defense would have you believe that Mr. Reyes couldn't understand what was happening because he didn't have his glasses. Go back and listen to his statement when he asks Officers Ramirez and Robles for what is really important to him. It's not his glasses, it's his recording equipment. It's because he doesn't need his glasses. He doesn't need them in that moment because he understands perfectly well what's going on. Defense would have you believe that Mr. Reyes couldn't understand what was going on because he suffered a head injury. But they provide no medical evidence that he ever complained of a head injury at the hospital. No diagnostic criteria. or
I'm gonna object to
evaluation.
burden shifting at this point, Your Honor.
Right, that objection will be overruled.
Or evaluation from doctors or any other personnel about what his mental state was, or even what injuries he suffered. Moreover, in all of the statements that he made, does he complain about physical pain? Does he complain about a headache? Does he complain that it interferes with his ability to understand what they're saying? No, he does not, because it isn't. But the best contradiction for what the defense would have you claim is that Mr. Reyes got on this stand and got confused, apparently, by the defense's own words, by the state's own words, by the state's own question. What, did he suffer another head injury over the weekend? No. He's trying to keep his story straight and he can't. Because while he's claiming that he's being honest, he's not. And he's not being honest because he knows he's in an incredible amount of trouble. A courtroom is a crucible. It's a place where irrelevance and the extraneous get stripped away. And ultimately, what remains is the truth.
5 minutes.
And the truth is this. Mr. Reyes knew what he was doing. He knew what was in that bag. He threw it away because he was scared, and he was scared for a very good reason. Now the consequences have caught up to him. When you review all of the evidence that we've submitted to you, the truth that you will conclude is that he is guilty. Thank you.
All right, ladies and gentlemen, Deputy Laura will take you to the back. All right, everyone, the court is gonna take its recess unless there, Carolyn, do you have someone?
I just am here only to say hello to the court and this lovely lady actually had you guys one of her professors. She also.
Oh, come on up. Oh, yes. All right, thank you.